May I please, your lordship?
Yes.
I beg to mention item number 25, lordship. Lordship, matter become infrastructure, lordship. So kindly allow to withdraw.
Okay. Learned counsel for the petitioner submits that this matter has become infructuous. Accordingly, the present disposition stands closed on being infructuous. Interim order, if any, stands vacated.
Or like that.
I'd like to mention item number 47, my lord.
Yes.
The conducting counsel, Mr. N. Islam, is it as form for marriage purpose, my lord, and the brief is also with him. May I pray for
For the
adjournment?
petitioner,
Yes, I am for the brief.
what about PNRD?
Till the affidavit has not been filed. my
That is important. Where is PNRD? Wait for something. Yes,
Wait, please, your lordship.
yes.
Lordship, I beg to mention item number 33, lordship.
30.
33, lordship. Lordship, the matter pertains to a demarcation of a plot of land, lordship.
Mm.
The engaged senior counsel is suffering from fever, lordship. Lordship, may I please to pass over the matter for today.
Under prayer of the learned counsel for the petitioner seeks for an adjournment on the ground of his on the ground of the arguing counsel and the arguing counsel being indisposed. Full stop. Prayer is not opposed. Full stop. Accordingly, matter stands adjourned and be listed after 4 weeks.
Much obliged.
May it please your lordship, would you
Yes.
consent with the other side? I beg to mention item number 24 and 41 of the daily list, my lord.
20.
4 and 41. Our instructions are being awaited, my lord. I'm praying for further 3 weeks' time to file our affidavit.
Learned Standing Council for Taxes, Finance and Taxation prays for an accommodation to enable them to file affidavit in opposition. Prayer is allowed. Please, this matter after 4 weeks, interim order pass earlier shall continue.
24 daily interview.
24, same order. And 30,
41.
41, my lord.
same order.
Call your blessing.
In 41 also there is an interim. Yes, 41,
My lord,
41.
there is an interim.
Interim.
May I
May I-
please your-
Yes.
Lordship, I beg to mention item number 37. The item may kindly be adjourned for next week because my senior counsel is suffering in fever.
Okay. On same order, indisposed. There is no interim order here. No. No interim order, huh?
May I please your lordship, I beg to mention item number 20 and 34, lordship, of today's daily list. I've taken concern from the other side, lordship. We are filing affidavit today itself, lordship.
Interest subsidy.
Yes, lordship.
20 and
20 and 34.
what about 34? It's your interest subsidy.
Yes.
Agonist to file affidavit in opposition 6 weeks. No interim order.
We're filing it today, your lordship, will
Today
take some time to file a reply.
Okay, after 3 weeks.
Obliged.
Like,
Please, your lord.
Yeah.
Lordship, with regards to item 63 of the supplementary list, I filed an affidavit in reply to the lordship. So I am praying for taking of the matter, taking of the affidavit with the case record.
Okay, we'll take some other day. We'll bring it, we'll ask the registry to take it. We'll fix it some other day.
Update may be given.
Yes, sorted,
Because
sir.
there is an urgency. Lord.
Okay. It seems that there is no urgency.
So there is.
Therefore, you have filed this affidavit
No,
today.
no, the petitioner is from Tezpur, lordship, for that.
Mr. Decca Learned Counsel for the petitioner submits that an additional affidavit
Affidavit in reply.
in reply has been filed by the petitioner today. Full stop. Same is not in record. List this matter on Monday.
There is an interim order.
Monday, along with the affidavit in opposition stated to be filed. Full stop. Interim order pass earlier shall continue till the next date of listing.
May I please, your lordship? Lordship, I beg to mention item number 56.
56.
My senior TJ Mohanto is in, he had some difficulty. So only for today, it can be listed next week.
56 supplementary or what?
No, daily list, Lordship.
Huh?
56.
Where is that? Which list? Okay, hearing, no? Okay, under prayer of the learned counsel for the petitioner, matters then adjourned and be listed after 3 weeks.
Right,
Yes,
Lordship.
Lordship. Lordship, I beg to mention item number 19. Lordship, we have
Item
instruction
number?
19. We
Yes.
have instruction from our client not to press the matter.
Learned counsel for the petitioner submits that they have instruction from client to not to press this present writ petition. Accordingly, this is item 19, isn't it? Accordingly, matters then closed being dismissed being not pressed. Interim order, if any, stands vacated. Yes,
Wait, please, Lordship. I beg to mention item number 38 of today's list, Lordship.
38.
Lordship. Lordship, in this matter, the respondent number 4 has filed the affidavit in opposition. I to file a reply, Lordship.
Mr. M.K. Bora, learned counsel for the petitioner, pressed for and is granted 3 weeks time to file reply affidavit to the affidavit in opposition filed by
Respondent number 4.
respondent number 4.
Interim order.
Interim order pass earlier shall continue.
Obliged.
Transportation of cattle.
Yes, Lord, thanks for this.
Yes.
May it please, your Lordship. Lordship, item number 29, Lordship. The impugned order has already been cancelled, reinstating the earlier order which favors the petitioner.
Hmm.
In view of the above matter, may be closed, Lordship.
You are for the petitioner or the respondent?
Respondent, Lordship.
Huh?
I am for the writ petition.
You are for the writ petition.
Yeah.
Full stop. The learned counsel for the writ petitioner submits that the grievance raised in this petition by the writ petitioner has already been redressed. Full stop. Mr. P. Bharadwaj, learned counsel representing the respondents, ascertain such fact. Full stop. In view of the aforesaid, the matter stands dismissed, having no surviving cause of action. Full stop.
Of the private respondent.
For the private response.
Obliged.
Yes, Mr. Das.
ADC has appeared, Mala, this person in the.
Yes, now what do you propose to do?
Mala, yes, one record is there, Mala. There only payment has been made, that remark is there. But honorable court was not satisfied with that.
Of course, suppose this may
Yes.
so happen, in any case, you will come and money is paid.
Mala, no,
Money may go to the pocket of some Latmandal, money may go to the pocket of some officers, who knows that? And it is a specific case of the petitioner that I have not been paid.
Mala.
Now, if that is your stand, you have taken a stand, I have paid. Now show us the proof or pay him, that's all. Money is not paid in that way, some signature, something is to be done.
Yes. In this record only that remark is there, Mala.
Remark by whom?
Remark there, no,
Remark by whom?
there to remark.
The remark may be written by the senior assistant itself.
No,
Since it
may.
is an old-
No,
old
may.
record,
Say,
we cannot-
say in all confidence that this is,
I cannot say for certain who has written.
no,
the-
he cannot say for certain. So therefore, the result will be directed to be paid, however, how you arrange it, it's your. Because you are not
67
disputing that
because-
land is acquired, you are not disputing that he was the landowner. What is your stand is that we have paid. He said, I have not received. Now, in that situation, you will have to say that we have paid it. Because there will be proof of payment. Compensation cannot be paid like this, then everybody will, money will go to anybody's pocket. And those beneficiaries will run like this petitioner. Pursuant to this court's earlier order dated 14/3/2024, 6/6/24, and 25/6/2024. The additional deputy commissioner, Mr. What is your name?
Priyanshu Bharadwaj, sir.
Priyanshu Bharadwaj, additional deputy commissioner, revenue,
Land acquisition, sir.
additional deputy commissioner within bracket land acquisition, Kamrup,
Kamrup Metro.
Kamrup Metro is personally present with records of payment of land acquisition compensation to the, yes, petitioner.
More time because.
No,
now
no,
it-
definitely. That is, we are not making any direction today. We are giving him a chance to file an affidavit.
Lordship,
We cannot pass orders like this. We'll record what is his submission, produce a record to show that payments have been made. Full stop. Just give me the record. In respect of the land in question.
Huh?
969.
Number 968,
Huh?
69.
9.
9/68, 69, Malad.
The record which it's a register, payment register, which according to the learned, according to the additional deputy commissioner, is a payment register for payment, register of payment. Shows a comment reflects a comment that awarded amount has been paid. Full stop. However, beyond that, there is no record to suggest that in what manner such payment was made and how the acknowledgement of such payment was received from the beneficiary of land acquisition. The deputy commissioner is also not sure who has written and who is authorized to write such a comment, that too without signature, seal and signature of anybody. Full stop. In the prima facie view of this court, such document cannot be a proof of payment of land acquisition compensation, in as much as procedure prescribes for payment of land acquisition compensation do not prescribe such a manner. Full stop. In view of the aforesaid, the learned deputy commissioner shall file an specific affidavit explaining the aforesaid observation, that is in how and in what manner the land acquisition compensation has been paid and how they can establish that actually the land compensation was paid to the beneficiary from whom land was acquired. More particularly in the backdrop that the petitioner has specifically asserted that no acquisition compensation has been paid to him. List this matter on list this matter on 38th of August.
We'll get time to also.
That's
charge
right.
the-
38th of August. 30th of August, full stop. For the present, the personal appearance of the additional deputy commissioner is dispensed with, subject to the condition that affidavit be filed on or before 38th of August 2024. The additional deputy commissioner shall also be at liberty to produce any additional document, any additional authenticated document to show proof of payment to the petitioner. The original records produced is returned back to the additional deputy commissioner.
Deputy.
Withdrawal.
Lordship, I'm
Why you want to withdraw?
with liberty, Lordship.
Why?
If required, Lordship,
What is the issue?
regarding settlement of
Mutation and cancellation of record, Lordship.
Mutation and cancellation. This is not the court.
Lordship.
It is the court is the
Revenue board will get those, Lordship.
revenue court,
Yes.
either deputy commissioner, if it is by the settlement officer, if deputy commissioner by the board of revenue.
That's why we.
What liberty?
we are-
Liberty will get when the board, the revenue. Board, okay. Present writ petition is filed assailing order dated no, sorry, just write it. The learned counsel for the petitioner submits that he may be allowed to withdraw this petition and with a liberty to file a fresh petition if fresh cause of action arises. Prayer is allowed. Accordingly, this writ petition stands dismissed on withdrawal with a liberty as prayed for. Interim order, if any, passed earlier. Any interim order? No, not necessary.
Yes, Lordship. Maybe, Lordship.
Yes.
Your Lordship, 483 application, Your Lordship.
4 application under
483 of the BNSS, Your Lordship.
483 BNSS. Why this matter is listed before this court?
Your Lordship,
How many days?
80 days behind the bar, Your Lordship.
Gold.
80 days, my Lord.
Gold.
Not gold.
Smuggled gold. Or what?
Yes, sir.
Fake gold.
Not fake gold, Your. Some robbery has been committed, Your Lordship.
You are who are you?
I am, Your Lordship.
Tezpur. This is from Tezpur.
Not, Your Lordship. It is from
Hattigaon.
Hathigaon PS, Your Lordship. FIR is on page 10, Your Lordship.
One order is at page 26 and Lordship has adjudicated, right? That is why it has.
This is second time.
No, Your Lordship. First time.
Another co-accused, man. Page
Who accused we have rejected?
26, Lordship, page 26. man.
Allowed. Where is that?
Allowed. Page 26. Is BA, man.
Page 26.
That is also BA.
BA. man. But here.
Page 26.
Starting from page 23, Your Lordship.
Dispose of.
One thing, madam, I just want to take the instruction whether any search, because 80 days has gone, whether any CS has been filed. That only that part.
Okay, have it after some time. Otherwise, you're allowing.
At two,
Have a telephonic.
yes.
Two, I do not know two. I'm not keeping well.
In the course of
Yes.
the day, I just.
As per inspection of the documents, Your Lordship, no charge sheet has been filed.
Okay, just have a wait for some
If
time.
he has
You be here.
justified-
If he has confidence, we can
Yes,
allow. Dispose of. Like
Obliged.
page 26.
Oblige, Your Lordship.
And record, it may be recorded that he has said, his submission that no search sheet has
Okay,
been
no search sheet has been filed.
as per the petitioner.
Till today, Your Lordship. Till
Yes,
today.
tool.
Hello.
Yes, what happened to Billal?
Okay, Your Lordship. It is a 483. It is a petition under section 483 of BNSS, Your Lordship. Petitioner has completed 98 days as on today, Your Lordship, in the custody. It is second.
What is the offense?
Offense under section.
Pokso.
Also not, my lord. It is under section 509 of IPC, with section 67A and 67
What is the FIR?
Information Technology Act.
So you want to say statutory period is over?
Your Lordship,
Search sheet not filed.
not filed.
Submitted the search sheet.
Yeah, no.
Agora order plus a rejection. What is the earlier order?
Is number page
17.
Your Lordship, 17.
You are MS
Begum.
A Begum.
Take the instruction, Lordship. I'll just telephonically, I will just.
You have the
inform them.
instruction. Otherwise, you are Billal Hussain, similar order,
Yes,
earlier
otherwise.
rejected.
Both these cases. I will
Already
take action.
considering the period of detention, statutory period is over. Dispose of. No other ground is required. You have it instruction.
Both the cases, I will.
Yes.
Oblige, Your Lordship.
Please, Your Lordship.
Yes.
Your Lordship, may kindly pass over the matter for the time being, Lordship.
Time being.
Lordship.
Where is Cal? I think this is settled already.
Yes, Lordship.
Notice interim prayer decline.
Lordship, order to repetition, Lordship.
Along with, this to be listed on 30th of August. You file affidavit, we will decide on that.
Highly obliged. Obliged, madam.
May, please, your lordship.
Yes, Goswami. Let us see the first FIR
Lordship.
on 38th,
Page
38th of
19,
it,
page 19, my lord.
page 19.
It starts, my lord, at page, the typed copy is at page 23. May I read, my lord? I am forwarding herewith the below noted arrested accused persons who have been arrested in connection with. No, I don't know.
Yes.
It sounds like it. Page 21, my lord, I'm sorry. It's dated 5th of May, my lord, 21. With reference to subject cited above, I have the honor to report that as per confidential information, I, along with team of Sadka Police Station, accompanied with Crime Branch Guwahati City Commissionerate, conducted search and raid in the rented house of owner Srimati Ila Kumari.
This is Rajgor. Then
Panjab-
somebody,
Pa-
another
Panjabari.
was, huh?
Panjabari.
Somebody was found in Kamakya. This is the case.
My lord, this is a case where, my lord, male and female were arrested, my lord, and there were subtenants. The allegation is that I had subtenants, my lord, and there is evidence, my lord, which I may place, my lord, that it was found from the room of the
Earlier rejected by this court.
no, my lord. One,
This is first time.
yes, first time. First time means yes, first time.
And earlier rejected.
No, not rejected. Co-accused was granted bail.
What
wide
was granted by this court, that we
But-
know.
Yes. Not rejected, my lord. This is the first time, my lord.
First time.
Yes, my lord, perhaps my lord, earlier he is on interim bail, my lord.
Yes,
Yeah.
I'm on interim bail. my lord.
But now surrender,
I'm on
But
interim bail.
bill, why?
Interim bail, my lord, because the records were not there and I
You
had,
were not arrested on the spot.
no, I was arrested. I've been in
They were arrested, but there is an order, my lord.
Ah.
Lordship may kindly, I have a flag mark in the, my
Yes,
lord,
sir.
the petition is not before me, that's why I have flag mark in the, my lord, LCR portion, my lord. Like,
Yes, 2.5 years I was in jail. I
Mm.
continued to be in jail from the date of this,
Now,
arrest.
when bail was granted, where is the order?
My lord, the bail was granted
On,
on 7th February.
by this court?
Yes, and I was released on 11th
On
March.
what
my-
ground and bail was granted?
My lord, because the copies were not there and on health grounds, my lord, I had to, I had developed, my lord, multiple medical issues while I was in custody. And even before I had issues, but I developed multiple issues and
After 9/7 to 2024, what happened on the dates? Did you appear?
it was continued, my lord, and but I appeared in the proceedings also when I was in Guwahati.
That is what I am saying.
Yeah, after-
Are you participating in the
Yes.
trial?
Yes.
Yes, we will make it absolute.
yes, my lord.
2.5 years.
8/4/2004, he has to surrender, my lord. But 8/4 orders are not there, my lord.
8/4 surrender before whom?
Before the, my lord, the trial court, my lord.
Before the trial court,
Where
but
did you surrender?
no, I have not surrendered because I am under medical treatment. I informed that to the court.
Then what order was passed?
My lord, only a date is fixed.
Any order passed that is not surrendered? Where is that
No.
order? This is very vital.
This is very vital.
See, we cannot see.
Okay, my lord, so
At
far
least it was a responsibility either to come to this court saying this, please extend.
I came, my
Any application filed here?
yes,
Where is that?
application date.
IA?
It must be on record, my lord.
No, IA number. Record will find it out.
Sorry. I filed an application on the same date, my lord.
my lord.
On 31st. The date on which I was asked to surrender on the same date, my lord.
What is your name?
My lord,
Cookie.
H Cookie, my lord, a difficult name. Hatnil Cookie.
So thereafter extended up to 24/7/2024. What happened on 24/7?
It was listed before this court. It was listed before this court, but since that application was not on record that day, so it was listed again and thereafter it was extended.
Where is that?
The public prosecutor had taken time. And
Where
it
is,
was
where is that? See, madam, you must be clear. What happened on date that this was the date?
The facts has to be clear.
Clear.
Yeah, my lord.
You
I
make it clear, do your homework a little bit, then come back to us after some time. These are vital issues.
Yes, my lord. I was
When it was extended and what happened on the next date, we'll have to record it. We cannot by mercy give a break. Yes, next
Yes.
case, next case.
LCR is
my
still
lord.
marked.
Go through and give a date.
My lord.
When it is. Item?
For application lordships,
Yes.
are rejected by your lordship.
In 43, my lord, lordship, it has been seated, my lord.
My lord,
Are seated, no interim.
no entry. My lord.
CS number 94/24 dated 1/7/24.
Some liberty may be cancelled actually.
That is there. I already will observe appear before the before the
That
appropriate
may be
court.
considered lordship.
Huh?
That bill, that application may be considered by the law.
That will be.
I'm of that.
Please, your lordship.
Yes.
Lordship, the steps has been taken on 29th.
Steps
Taken
taken. When?
29/5/2024.
What about respondent number 4?
Lordship, I am not the engaged counsel. Senior
You
inspector.
need not be engaged to stand before this court. You can go through the record. What happened to respondent number 4? In view of office note dated 17/7/2024, the learned counsel for the petitioner submits that she may be granted 5 days time to take fresh steps upon respondent number 4. Prayer is allowed. Please this matter after 4 weeks.
Right, please, your lordship.
Yes.
Lordship, in this matter, actually, I'm not in contact with the petitioner. I tried to contact him whether the matter is still subsisting or the matter has in between settled, your lordship. Just 1 week time, your lordship. If the matter is settled, I'll withdraw your lordship, and if the matter is not settled, I'll take steps as per his instruction. Relates to a proceeding of recovery by the DRT.
Sorry.
You will grant me only 1 week time, your lordship. If the matter is settled, lordship, I'll withdraw, and otherwise also I'll. And
Otherwise what? Let us assume that matter is not adjourned, settled. Then
I'll take the step. I'll take
recovery. What instruction? It's a question of law.
There is a order of this court.
May be order of this court. These interim orders are not absolute or binding upon us. We'll have to consider
3
on
days
May.
time, then lordship.
Huh?
3 days time by Monday, your lordship. I'll.
Friday. Learned counsel for the petitioner submits that he may be granted time till Friday to obtain instruction whether any cause of action survives in this present writ petition.
Oblige, lordship.
List accordingly on Friday. To it. The present petition is filed. Copy koriba. None appears for the petitioner on call. None appears for the parties on call. Then the number paragraph 2. On the earlier occasion, on 24/7/2024, comma, Mr. S. Datta. Then second paragraph. At that stage, the learned counsel for the petitioner took time to obtain instruction in this regard. Full stop. None appears for the, but as none appears for the parties on call, the matter stands dismissed for non-prosecution.
47.
Yes, PNRD.
We have not received our instruction, Lordship. Lordship, kindly 2 weeks time maybe give him Lordship.
Okay, learned counsel, standing counsel for PNRD submits that she is awaiting instruction and therefore 3 weeks time may be granted to complete her instruction and to file affidavit if so advised. Full stop. Prayer is allowed list after 4 weeks.
The application for review. The input judgment logic page 56.
Yes.
The case related to the interlocutory order of induction. And Lordship is purchased order on is page 56. Only basis of it is a review petition. I am not only show you Lordship what is the error apparent in face record. Lordship when it is purchased order on consideration that
Are you ready?
primary.
Just are you ready?
Lordship, my brother was admitted on last evening. However, I am not fully ready. Your Honor.
Learned, we do not want to half-hearted because if he says that's why he's looking at his face, I could understand it. After 10 minutes, this matter will be adjourned. So, learned
Then what
counsel
is it?
for the respondent submits that due to his brother's hospitalization, he could yesterday night, he could not properly prepare this case. Accordingly, he seeks for an accommodation. Prayer is allowed. What is the urgency?
Urgency? The status quo order has been given. Earlier the court refuses to give this injunction. The court, this court, the whole that there is a prima facie case and balancing convenience is decided by the trial court, and therefore there is no question for or not giving the injunction. But that is if that is so, that is correct. But this is otherwise. On that, because on record is not called for, on the submission of the Lordship relied this. In fact, the judgment says the balancing conditions are not in favor of the in judgment. It is clearly lettered.
Okay, no, I'm asking, will that is a merit. What is the problem you are facing at this?
I think the case on basis of the
Who is possessing this land? Who is possessing this land? Who is possessing the land?
I am in possession, but I am in
You
possession.
are not been able to develop this land. Okay, let us take up this matter on 19th of August.
Can it be?
Not possible.
Because if I am on that day, also endeavor to.
Then you will have to do it either virtually or you will have to come to Arunachal.
That is the.
Because this matter will be attached to.
No, only.
No observation today. 19th. Wait, please be ready on 19th.
That on that day, the endeavor will made to the.
This will come to this court. This
Yes.
endeavor is always there in this court. Don't worry about that. I am having always that endeavor so that matters can be.
Last 2 occasions, Lordship picks the matter in 2 occasions. On the them they take adjournment.
That's why I'm saying next date we'll complete this.
19 August.
And there is no problem if you have committed mistake to review. I am open to everything. Yes. Yes, what is the error apparent?
Lordship has the order of the division bench on the day it was reported. something was not pointed out to this honorable court, my lord, which led to an error, my lord. Lordship, will page 62.
Yes,
62. One judgment of the Honorable Supreme Court was not brought to the notice, and at page 62, after attempting to argue the matter for some time, the counsel for the appellant contended as a matter of fact, at the time of final hearing of the writ petition before the single judge, counsel for the appellant failed to bring the notice of the court the provision of
where? Page 62.
62.
Okay.
After attempting to argue the matter for some time, learned counsel for the appellant contended that as a matter of fact, at the time of final hearing of the writ petition, the counsel for the appellant failed to bring to the notice of the court the provisions of Rule 102 of the CRPF Rules 1955, which clearly provided in respect of matters for which no provision is made, they shall be the same as are for the time being applicable for other offices of Government of India. It is submitted that as per 102, the provisions of CCS would be applicable. Lordships, since it was not pointed out to Lordships, Lordship would find at page, my lord,
Mr.
Repeat.
R.D. Mojumdar, learned counsel for the petitioner. The present review application is filed seeking review of
the order, my lord, dated 10/12/21 at page 49,
seeking review of order dated
10/12/21,
10/12/2021,
passed in the
10/12/2021, passed in WPC 1755/2024. Issue
2014.
notice,
2014.
2014. Issue notice. Who will?
My lord,
Yes.
Mr. Akiri Chaudhary had accepted notice yesterday. He was supposed to appear. Perhaps he
Okay.
did not go through the list.
Okay, as is he available here? Mr. R.K. D. Chaudhary, learned ASGI, accepts notice on behalf of all the respondents. Therefore, formal notice may be issued. However, extra copy of the review petition be furnished to Mr. Chaudhary. Full stop. Place this matter in the order column on
Lordship's convenience.
on 27th of August
Obliged.
in the order column.
May I appeal, your lordship?
Yes,
Lordship, our grievance of the petitioner in the main case is, lordship, the respondent authority started work, lordship, construction of a road work, lordship, which was earlier, lordship, 11-12 foot, lordship. Now
what is your prayer in this writ petition? First,
petition is, lordship, the respondent authority without disturbing, without acquisition of land, lordship,
Mm.
acquisition process, lordship, they have started their work, lordship, and it will demolish our houses, lordship. These houses were very old houses, lordship. Since our forefathers, lordship, we are living in this village, lordship. So their plan, lordship, to construct the work, lordship, by placing a bamboo stick, lordship, covering our area, lordship.
this is national highway
No, lordship.
by state.
Yes, lordship, it is a small road actually, lordship, about 11-12 foot, lordship, earlier, lordship, and now, lordship, they have about 64-65 feet, lordship.
This is for
covered.
development of the people like you. You will have a 60 feet road.
Lordship, but we will be homeless, lordship, otherwise,
No,
lordship.
you will not make you homeless. Yes, what is your
Lordship, in this matter, in main case, affidavit has already been filed.
what
my
is your
lord.
stand?
A stand has been taken that no requisition has been sent by the requiring department, my lord, for acquisition of land. But we have made a assessment, my lord, that is annexure C to the writ
No.
petition, my lord.
What is your stand? Whether he is occupying a patta land?
Zirat has already been prepared, my lord.
Now, what
regarding
about
his
the compensation?
It is forwarded to the additional chief secretary to the government.
Then you are
department.
saying it. Forget about the road. Yes.
Or
Where is the
that's the
affidavit?
department.
Writ petition. That cannot be. That will construct a road and we'll bring
It's a
the
clear stand in
Jirat.
the affidavit,
Yes,
my
you
lord.
can requisition the land if it is urgent in nature and all. This
Nothing,
is
no.
not the way.
We
You
have
are not monarchs.
no communication has been received from the requiring
You
department.
will ask the who is requiring
Water
department.
research department.
Where is water resource? Yes.
Senior Mr. Arendra is on, he's on legs.
Okay, let
don't
him,
have-
we'll wait for some time. Water issues, it's a embankment or road?
The restoration of dike, my lord. The project related to restoration of dike.
Restoration of dike. Your stand is that they are in
It's not
patta land.
Yes, dear Pattalan, accordingly, we have make the proposal for estimates, my lord. And that is being forwarded to the additional chief secretary of Water Resource Department. Among that,
This is your stand.
yes, my lord, we have taken the stand in affidavit. Annexure C is the enclosed.
Now, what
matter,
is
my
the
lord.
stand as on date? Your house is there?
Yes, Lordship.
Okay.
No earthwork was started, Lordship,
Okay.
still.
Sir, we have not received any correspondence, my lord, from the
Okay.
requirement.
Your affidavit is there?
Yes, yes.
Yes, okay. This is Karbi Anglong or what?
Hailakandi, Lordship.
Hailakandi, district Hailakandi.
Okay. Call Mr. RM Das and ask him to come with the instruction that if the government, if we accept this government stays, we are going to stay the work.
I is for the rest of.
As simple as that. Ask him, have instruction and come back.
Obliging.
My lord, in this case, I'm appearing on behalf of the private respondent, my lord, respondent number 4, my lord.
Yes.
Today we have received the instruction, my lord, so
Okay, Mr.
casing.
Singh, K. Singh, Learned Counsel, appearing for on behalf of respondent number 4, press for 2 weeks time to file an affidavit.
Yes.
You know, please.
Number 52 lordships.
Huh?
52 item.
Yes, what is 52?
That's it, matter will be taken up after some.
Why? Who is your senior? What is the issue here?
Lordships, in respect of item number 52 lordships. total
Same
fee-
issue,
Different issue lordships.
then why it is take together?
Lordships, there some other plot of land and this is some other plot of land. And both the land belongs to railway.
Both the land belongs to railway.
Lordships.
Then
And here in respect of 52 lordships,
I
there
think
is 9 lasas of land,
you are railways.
lordships,
Okay, according to you, land belongs to railways.
lordships.
Now,
Lordships, this
what is the
already,
grievance of the railway?
lordship, this,
Mighty railways.
already this, a direction was issued
Hmm.
by the state officer
Hmm.
that you approach to the deputy commissioner and police lordships and recover the land.
Hmm.
Lordships, accordingly, we have approached before the deputy commissioner and superintendent of police.
Hmm.
Lordships, no action is taken.
Hmm.
Thereafter, lordships, we have
So you want to say you in exercise of power under unauthorized eviction of unauthorized occupant persons were directed to be evicted by the state officer. Now state officer wants police assistance. Isn't that it?
lordships.
Now the state is not affording you police assistance. This is the grievance of the railways. Now what is the other petition 51?
51 lordships.
My lord, in 51, my lord, I have already gone through it. They are seeking for demarcation and correction of records.
So 51 are the persons whom they are seeking to evict. These are the persons.
No, my lord. This is only for correction of record and demarcation.
Now why these two matters are listed
don't know.
together? Give the 51. Who is representing 51?
MS Bora lordships.
No, Vilas of I of it.
She has filed on miss case also lordships earlier.
Complete matter is also-
51 is 1, 2, 3, 5. This is also Union of India.
Yes.
Lordship, Railway lordship, railway land.
Okay, here is a case you have acquired a land by paying compensation and they are not correcting the records of right. This is your case. And in second case, you want to evict from the same land. You are not aware.
Lordship, some other land, Lordship, not the same land.
Be sure.
Lordship, my DAG number and Pata number is given. On the other
What is
hand,
your DAG
Lordship,
number? Tell us.
Lordship, page 17,
Forget
Lord-
about the page. Tell us the number.
Lordship, DAG number 18, Lordships.
Ah.
Village Garpandu, Kumarpara,
Hmm.
Mauja, Jalukbari, Lordships.
Milan measuring
Land measuring, Lordships,
67 bighas.
not 67 bighas, Lordships. 40 m into 30 m. Meter, 40 meter into 30 meter, equivalent to 9 lasas of land.
Okay. Now what to be done today? Who are you?
My lord, I am the private respondent, my lord, newly implemented respondent, my lord.
So you are the persons who
Yes.
is sought to be evicted.
No, no. My lord, here the railway is saying that now in the year way back 1969, they acquired some land amount to 63 bighas of land.
Okay.
But we are
Agar
placing
order.
our land. My
You
lord,
want to
we may be
file
allowed
an
file
You
affidavit.
want to file a petition?
Yes.
Please this matter after 4 weeks. Agar order to থাকিব after 4 weeks. Yes.
I am for 53, Lordship.
R Sharma for in item now in WPC so and so item 52. Sorry. Gaur pailo aru dia. Yes.
Lordship, we had filed a IA for substitution of the legal layers of respondent number 4.
Respondent number
4,
IA.
Lordship.
You are the petitioner.
Yes, your Lordship.
Yes. The present application is filed by the writ petitioner seeking substitution of the respondent number 5,
4,
respondent number 5 who died.
4, Lordship.
Huh?
Respondent number 4, Lordship.
That's right. Who died
Respondent
on
on
who expired on
1/6/2022.
1/6/2022 by his legal years as detailed at paragraph 2 of this petition. Paragraph 2 of this petition. Mr. M.S. Bhattacharya, learned counsel for the respondent.
4 and 5.
I'm for the.
For respondent number 4 and 5, and Mr. Sharma for the Jorhat Municipal Board. Publish that they have no objection in substituting the deceased respondent number 4 by his legal years. Mr. Peruse the application and the statement made therein. Full stop. This court is of the opinion that the right to sue survives accordingly. The legal legal years of respondent number 4, who details of whom are given at page 5 of this patent application, be substituted as respondent number 4A, 4B, and 4C in place of deceased respondent number 4. Registry to correct the cost title accordingly.
Right.
Petitioner to furnish a amended cost title to the registry in terms of the extent norms. Yes, no.
We can dispose it.
Huh?
Right on the later.
What do you say? We can dispose of?
On last occasion, Lordship,
How we have
Lordship, last occasion, direct me to whether this case has been disposed of in light of the order dated 4/4/6/2015.
okay.
Lordship, in this case, we file an appeal. The appeal in the appeal said that refund is not admissible. It is refund. So dispose it.
My lord,
Hmm.
this is covered by this judgment, but as far as that aspect of refund as far that is concerned, Lordship, in our case, it is different because we are bringing the goods into the state of Assam only for our own consumption, Lordship. In this judgment, which he is referring, and I also referred last time, Lordship, in this case, the goods were not sold on MRP basis. In the writ appeal, they have clarified, Lordship. Lordship, may kindly take up the writ appeal order, Lordship, writ appeal number 288, Lordship. In that, Lordship, the relevant portion will be page number 8, Lordship.
Page 8.
Page 8, Lordship.
Hmm.
Page 8, Lordship, may I read?
Yes.
It will be a case of, therefore, the decision in the
Page
case,
7.
page,
Eight, Lordship.
page 8, Lordship.
This is the division bench judgment in
Yes.
Assam Agriculture Marketing Board.
No, Lordship, this is the, yes, your Lordship, in the writ appeal. Tinsukia Trading, Lordship. Page number 8, Lordship.
It starts with therefore.
Therefore, the decision in the case of Sri Digvijay Cement Company Limited, Supra, relied upon by the learned counsel for the appellants would be more appropriate in the instant case. It will be a case of unjust enrichment if the cess amount which was collected from the end user is directed to be paid to the appellants, as no details of refund has been indicated with specific reference to the manner in which it will be refunded to the end user. Therefore, the direction of the learned single judge to refund the levy of cess collected would be unjustified, would not be justified. Hence, though the order passed by the learned single judge on merits is upheld, the direction to refund is set aside in terms of the above discussion, Lordship. Lordship, this is the
So you will make a distinction end user,
end
is
user.
not it? In those cases, it was used by end user. There is no scope for recovery from the end user.
End user.
Your case is that it is direct to the marketing board and they are the end user. So
No, Lordship. The end user is me, petitioner myself, Lordship,
Okay.
because I have a manufacturing unit here for using that refined oil for making hair products, Lordship. So I am bringing from state of Assam as a stock transfer, Lordship, for my
Okay.
own
this
consumption.
is not a final product.
This is not the final product. Otherwise, from coconut to coconut oil, this is a final product. Again, this product is used in my factory, for my
So
consumption.
according to you,
Yes.
it is not the consumer
Yes, it is.
who
I
will be
myself-
the end user. You
Yes.
are it is being used as a raw material for a final product. You are the end user.
I am the end user. So I cannot collect cess from myself.
Hmm.
So the cess has been paid by me only, whatever cess has been paid. So that cess may kindly be, because at the time when this matter was moved also, Lordship, Justice Goswami's order is there, Lordship. He had instructed, because they did not allow us to take an interim order. So it was instructed that all this cess amount collected from the petitioner should be kept in a separate account. And if we succeed in the petition, then this will be refunded to us, Lordship.
Where is the single judge's order?
Lordship, I have just played, Lordship.
This is Marico.
Just played.
No, Tinsukia Trading's original order.
Double 469. of 15.
4469, Lordship.
Where do we get that?
This.
Order dated.
This is 4469. Tinsukia, oh no, this is Hati writ petition.
That is 31st/7/2018, Lordship. Tinsukia Trading, Lordship, page number 7, it has been directed to refund the cess,
Just a
Lordship.
minute. Now, what is the finding?
Single judge lordship, page number 7, lordship. It starts from page number 6, lordship. Last paragraph, lordship. Applying the above.
Where is Digvijay Cement? What is the statement that this is used for harder product?
Paragraph 16, lordship. Of my
Paragraph?
16 of my petition. Thanks. Okay.
Paragraph 1660.
16.
16.
Paragraph 16F, lordship.
16.
F.
Just a minute. Yes.
That in the year 2016-17, the petitioner set up a manufacturing unit at plot number so-and-so in the state of Assam for manufacture of hair care products under the brand name of Parachute Advanced Nihar Natural and Hair Care. In order to manufacture the final product, the petitioner number 1 procures stock transfer refined coconut oil from outside the state, that is from Tamil Nadu, Kerala and Maharashtra, by way of stock transfer as well as by way of purchase from vendors.
No affidavit file. Huh?
Affidavit is ready, lordship. I will file it if required, lordship. Affidavit is ready, lordship. I have received the.
Now, here issue is she is correct until and unless you file an affidavit.
Lordship, I will file.
Here end user is she, because her specific statement is that I am bringing this oil from to use as a raw material for final product like Parachute Advanced Nihar Natural Hair and Care. So during the process, it will not be a coconut oil, raw coconut oil brought from Kerala and Tamil Nadu and all. So first point is, by virtue of the learned single judge's judgment, you don't have any power to levy anything on this oil, because the law is well settled that this is not the oil seed. It is not the coconut, because your responsibility is to protect the farmers. So therefore, it is the final product oil at that stage. In earlier case, therefore, what is her argument is that in earlier case, it was the final product of mustard oil. So it was sold to anybody, end user is somebody else. So therefore, that says it will be an undue gain, because those person who sold it, they have already collected that share from the end user. Isn't it? Here her case is that no, I am the end user. So there is a distinction between recovery. So we will have to pass a judgment making a distinction between the final determination made in what is this called? Tinsukia, and in this case. So that will require a detailed judgment. So you file an affidavit.
I'll file a detailed affidavit.
Heard in part, place this matter for further hearing on.
Allow 1 week time, I will file it.
Further hearing on 28th of August 2024. 20.
2-8 lordship.
2-8.
I'll file it.
This is the simple issue.
I'll file it
So
today.
we'll pass this since you are it.
2-8 lordship.
I say 2-0.
2-8.
2-8. Okay. So issue is simple. Now, one aspect you'll have to remember, you cannot say that this is not, you are not the authority to say who is end user. Now you'll have to answer who will decide that you are end user. This is your statement.
I'll have,
Who will determine that you are the actually end user? That question I will ask on the next date. This is only your statement.
lordship, I'll have to bring something on record so that I can prove.
You may,
I'll-
you may bring whatever you like, but you have the judgment of the Supreme Court.
Digvijay.
Okay.
Obliged.
Of course, you are end user because you are not a consumer. Your specific statement is that you are a industry and your product is something else, not that oil or you are taking in a tin and selling it to somebody else.
Mustard oil, that was the case.
Yeah,
Big
that was the
things
case.
and,
That was the case.
small.
Now, suppose you use this, you have already used this, sold this, okay? And you have collected a percentage from the final end user of parachute oil. Now, will it not be an undue gain for you? Just these are the questions you will have to answer. As held in the division bench judgment, ultimately this payment was made. You will not give you from your own pocket. This was the understanding that you have collected it from somebody. In your case also, his argument will be end user is not you. You have share this sales imposed by them and included in the parachute final product. So you are not the end user. So this will be an windfall gain for you. And why should we give you that? Depriving a state marketing board.
Lordship, my argument will be. that
You give those
em-
answer on the next date.
Much.
Notice interim declined.
Subject, the tender process will be subject to further outcome.
Always. We have said, but we have made an observation. At that stage of ITT 4.2, you will have definitely have a right to once again challenge it. That we have observed. But orders may be late in the evening or tomorrow.
Already yes.
Where is Kejriwal? We
I,
can close it today itself.
you are giving consent on last occasion.
He was well aware.
Yes.
There are umpteen number of decisions by the authority themselves. So
Mr. Kyle accepts it.
the man sitting here as an advocate was also a victim of this.
No, I was also there.
Mr.
I've
B.P.
given a
Das was
notice.
also there.
Order is there at page 19.
And Datta was also there.
Yes, many.
Many.
And, but in our High Court, there is no judgment. But I find in Karnataka, my lord, there is a proper judgment.
But what they did is, some of the lawyers withdrew their writ petition, or some of the litigants even did not file the writ petition, approached them saying that this is wrong, and immediately they have passed orders. Immediately say that this is because these are notices issued by not by humans. It is by artificial intelligence. So they are not aware that whether it is lawyer or not.
Coming
But you
date
can
in-
close it. Where is Can?
SCK Lordship
Is in
station.
Agatal,
He's coming at.
Aizol. Aizol.
He is coming at
Yeah,
2
true.
PM Lordship.
But he agrees. But I.
Who knows? We will see 2 PM.
2
PM is too far. We'll see. If not, then we'll fix this on Friday. ঠিক orders নাকি বলা Yes, Das.
I'm sorry, Lordship.
Yes, tell us.
Lordship, the work of the dike is almost completed, Lordship. But regarding the query which your Lordship had raised regarding the Patta land or not, that is not being confirmed in our affidavit. That
No, not necessary. You are not the revenue authority.
Lordship.
The revenue authority says Patta land.
Affidavit, my lord,
Mm.
with the revenue village has been mentioned. I have
Mm.
specific duck numbers reflected, my lord. But that revenue villages are reflected in
What is your stand? Who is the counsel for the petitioner? Obtain your instruction.
Okay.
Both specific instruction whether the land is under revenue.
Patta
village.
land.
Patta land, full stop. The petitioner has filed this writ petition assailing that without following any due process of law under the relevant provision of Land Acquisition Act, the house of the petitioner is sought to be demolished by the respondent Water Resources Department. And accordingly, the present IA is filed for stay of further action of the respondent. Water Resource Department. So full stop. In the main writ petition, the Revenue Authority has taken a stand that land is situated in a revenue village, though they are not specific whether the petitioner are occupying any patta land. Full stop. Mr. Das, learned standing counsel, also submits that he will have to also obtain instruction whether the house of the petitioner is standing in a patta land and whether in the course of construction said house is to be demolished and whether any land of the petitioner has been used in the construction of the dike. Full stop. In view of the aforesaid, matter stands adjourned and be listed on Friday. Interim prayer shall be considered on the said date on the basis of the instruction that may be given, and in absence of any of such instruction, this court may consider the interim prayer on the basis of the statements made by the petitioner in the application as well as in the main writ petition. List accordingly.
Your pleasure, Lordship.
Mm.
My senior is coming, just he's here.
What is this issue? Tenancy.
It's a matter of tenancy, Lordship.
Who is your senior?
Yes, after. He's there, just.
We'll do it in the next week, Monday. Today time being is difficult. As Mr. S. Sapta, learned counsel for the petitioner is on list this matter on Tuesday next week. Yes, Kolita. You are for Gandhi or Masjid? Masjid. Who is for Gandhi?
Gandhi is the main law.
Who is Gandhi?
The learned senior is appearing into matter. Art it horse.
None appears for the petitioner for in WPC. 4-6, you are Gandhi or
Majid Lordship.
Masjid?
I
Four,
am for WPN 1 to 6.
460/2015. Accordingly, matters and adjourn and be listed on next Thursday. Tell me, what is the issue here?
Lordship,
Both of you want the same land.
yes, Lordship. Lordship,
What is the
during pendency of this proceeding, Lordship, 463 of the 2015 Lordship, eviction notice was issued
that
against,
is stayed?
that was stayed.
That is stayed.
That was,
And who is possessing agent it?
Lordship, they are also claiming for the possession. Our contention is that if they are
Don't
possessing,
fight,
Lordship, writ petition is not maintainable, Lordship.
Huh?
Because if they are possessing, Lordship, as per land was allotted to them, then Lordship, this writ petition is not maintainable.
You understand?
And the eviction notice was issued. in
But
terms
they are
of the-
also saying that your petition is not maintainable.
Yes, Lord. But Lordship,
What
eviction
will be
notice,
your alternative remedy?
if Lordship peruse the eviction notice, it says that in terms of the court's order, but there is no such court's order, Lordship.
Okay. We'll hear on next
Lordship, fixing Lordship on,
Thursday.
can it be?
Give us a date, give us a date. Give us a date.
After 8, Lordship.
Give a date after it. These are all matters. 14th.
What should I appear for the petition, the item?
Okay, petitioner in A2, WPC
463 of the
463 of 2020. As agreed. There is no scope for settlement between these two parties. Gandhi and we have adjourned it. For Thursday, we have adjourned it till Thursday.
Next,
Next Thursday. No scope. 14th of August. No scope.
With whom, my lord?
Both parties.
No.
No.
My lord, only
One is
thing
Gandhi.
Question is, my lord, as Gandhi.
Yes. It's a Gandhi. One is Gandhi. One is Masjid.
Also, Mondir also there.
Mondir is also there.
Mondir, my lord, they have just added, just to show the diversity.
Gandhi should lead both Mondir and Masjid.
Yes. And now we can speak to this, and let it not be recorded.
No, we will not record it.
Yes.
Just it was a idea.
My lord,
Read court making any observation will be difficult in this case.
phone is dangerous.
Yes, APDCL.
Look, these three petitions were directed.
Now they say that it is covered by some determination. You say that yes, it is covered, but not wholly, some part. What is this? And just find it out. I can take up this matters, no? Period is very dangerous.
But
These
I
writ
don't think
petitions.
that I have verified. I checked all the orders, my lord. Your lord,
Orders is not there, but Mr. K.D. Sharma's name is there.
in one of the cases.
He used to assist me, but I forgotten whether I appeared in these cases or not.
But in the rest orders, I have verified.
I have verified.
Yes,
Each and every order
Yes,
I have
my lord.
verified.
One order, Mr. K.
K.D. Sharma's
Yes,
name
my
is
lord.
there, and he used to assist me in these cases. Can you dispose it of today?
I'm ready, my lord. I will
Ready
say-
means how much time? We are not
the
going for
issue is
lengthy
otherwise
hearing.
Simple, my lord. He wants to distinguish it, and it will
My
take
lord,
time.
the issue is as to what will be the
Do you think that I might have a view? We argued many cases. As a judge, I will not have. Those are best for clients.
The issue is very on the narrow campus. my lord. The issue before the appellate authority as well as the assessing officer was that since the projected case against the petitioner is tampering and theft of electricity, so apply the mode prescribed in the supply code. It is the settled law, your lordship is aware, when something is manner and method is prescribed in the statute, then that procedure is to be followed. What they have done, though the pleaded case is that this is a case of tampering and theft of electricity, but instead of applying the provision contained under clause 5.8.44, read with serial number 9 of clause 6.2.1.1 and clause 3 of annexure A to the supply code, he applied the provision contained under clause 4.2.2.4,
That is the method prescribed for defective meter. Now, if you apply the provision contained under clause 4.2.2.4, then the precondition is that the meter has to be tested. Meter has to be examined in temper analysis field. There is nothing below. Their own pleaded case, your lordship may kindly take just item number 11.
11.
Yes. Page 102 below. This is the order of the appellate authority. This is the admitted position. He admitted that in fact the matter is covered by clause 5A44. But since they find it difficult, since the net result is negative, so he applied other mode. How he can permit, my lord? This is patent illegality, my lord. Deholds the statutory provision. Your lords may kindly page 103, my lord. My submission, my lord. I will take your lordship to Roman 4, small 4, my lord.
Now, if it is theft and theft of electricity is established, what should be the procedure?
Procedure is prescribed that the assessment bill is to be prepared by applying clause 5.8.44, read with serial number 9 of clause 6.2 and clause 3D of annexure. This is the procedure. And appellate authority admits, your lordship may kindly find at page 105 below. May I read below?
Yes.
This is subpara of the 105. The direct evidence like inspection report,
So it
CMR.
is established. They say that it is a case of theft and tampering. That is
So-
the finding.
We apply the provision, the specific provision, that is clause 5.8.44, read with clause serial number 9 of clause 6.2.11 and clause 3D of annexure A. Because your lordship is aware why these provisions were incorporated. These provisions were not there.
Now, whole question is whether to overcome the difficulty faced, a procedure prescribed for
Can be
theft or illicitity can be waived and a procedure applied for something else can be brought into
Yes.
the force. This is the issue.
This is-
Now, how it was answered in the other judgments?
It was answered, the calculation or the methodology that was adopted by the APDCL was found to be incorrect. There was a direction to recompute the entire assessment. Now they filed a review against that order and specific direction was given that the calculation in the case of theft and tampering of meter has to be in accordance with 5.A.4.4.
Yes.
That is their prayer in this repetition, that direction may be issued.
So you will have to set aside this order.
Yes,
This
madam.
has
The
to be set
recalculation
aside
has to be
and
done.
the recalculation has to be
To be
made.
done under clause
5.8.4.
5.8.4.4.
madam,
Read
Yes.
with clause 3D below.
Huh?
Read with clause 3D of annexure A. Yes.
No, it-
That's all.
Yes. Yes.
May I just place that judgment in review?
That was the inadvertent mistake. My lord. Clause 3D is omitted. My lord.
That has been granted given.
That was not given in this case.
Where is that 3D? Just show us the.
Yes, please. I am placing it. And the act is clear, my lord, because the assessment has to be made for the loss, my lord, as per section 154, subsection 6, my lord. It's
Where is the judgment? Where main judgment?
The main judgment, my lord.
Original judgment?
Yes,
Where
madam.
these are the same all four methods?
Yes.
yes, my lord.
So
The
you can
issue
pass
is-
a common judgment?
Yes, my lord.
Findings are also common, similar recording?
Exactly, my lord. As far as the appellate authority is concerned, my lord, the issue raised before the appellate authority was common, my lord. The assessment has to be made as per this.
No, principle, the appellate authority has concluded that this is a case of theft.
No, in such two cases, my lord,
Ah.
he recorded that foreign circuit was found. So this is a case of malpractice. And malpractice is defined under clause 5.8.
So if it is a malpractice,
Then
then,
this is tampering and interference.
then what should be the procedure?
That is theft of electricity.
The
Same.
Same will.
But
apply.
he applied the consumption figure. That is wrong, my lord, consumption.
That has to
So
be.
admittedly, in this judgment, it says that yes, this is a case of theft
Yes,
and applicable procedure is this.
yes.
But since there is difficulty, let us not apply this procedure, let's say
yes,
some other
yes,
applicable.
yes.
So that is not permissible in prima facie. So we'll set aside that and give them a permission to calculate in terms of this provision
Yes.
read with so
Yes,
which
yes.
was clarified in the review.
Yes.
In the
That's
review.
Yes.
Now, my learned senior is saying that annexure 1 is not being made a part of the order. My lord, if that has to be made a part of the order, then an I has to be moved, my lord. Because the order in the review is clear, my lord. The recalculation has to be done in accordance with 5.A.4.4, my lord. We are ready to and willing to do that, my lord.
As far as that just
No, not tell us, just show us the provision that
Yes,
in this regard, this has to be applicable, it shall be made applicable.
your lordship may kindly take up this. I have given the compilation.
This is.
Your lordship may kindly come to page 27 of the compilation.
Yes, 5.8.4.
3.2. Your lordship may kindly first see 5.8.3.2. I. Interfering and tampering with the meter and metering system as detailed under section 135 and 130 of the 38 of the Electricity Act.
So allegations against these petitioners are
Tampering.
violation under section 135 1.
Yeah.
This is, isn't it?
Yes.
135 1,
Yes.
not 138.
Not 135.
Yes.
Now, your lordship may kindly see 5A4. Lord, before I take your lordship to this provision, there is a requirement to see the electricity removal of difficulty. Why this provision is incorporated? You also will find at page 18 of the compilation.
Yes.
Because under section 135 1A, my lord, the assessment of electricity charges is required to be made. But the distribution license is found it difficult how to ascertain the loss because of the tampering and theft. The recorded consumption is available in the meter, but because they are alleging that there is a theft, then this actual figure.
How much stolen?
How much is stolen? That has to be find out. So this provision, this electricity removal of difficulty order was issued, authorizing all the commissions who have framed the supply code under section 50, allowing them to prescribe the method of assessment of electricity charges in the case of theft of electricity, pending adjudication by the appropriate. Your lordship may kindly come to serial number 2, page 19.
Page 19. Yes.
Inclusion of measures to control theft in electricity supply code. The electricity supply code as specified by the State Commission under section 50 of the Act shall also include the following, namely method of assessment of electricity charges payable in case of theft of electricity pending adjudication by the appropriate court. So this electricity removal of difficulty order was issued on 8/6/2005. Pursuant to this, Chapter 5A was added in the supply code. That is just now 5A32, now 5A4 million. The similar language, pending adjudication, 5A4.
5A page, this is
Page
27.
Page 27.
Okay, just take down. Heard, Mr. Kejriwal, Learned Counsel for the petitioners. Mr. Chaudhuri, Learned Counsel representing APDCL. APDCL. Any other respondents? That's for Mr. B. Chaudhuri, Learned Standing Counsel for APDCL representing the respondents. The as proposed by the learned counsel for the parties, these batch of writ petitions are taken up together for final disposal. Just correct me if I am wrong. The petitioners are bulk HT consumer uh, is having bulk HT consumer electricity line at their factories. Factory, all are factory?
Yes, we-
Factories.
industry factory.
Pursuant to an inspection of by a team of APDCL, it was found that meters were tempered, and accordingly, assessment process was started for tempering meter and also unauthorized use of power by the consumer. The matter went up to the appellate authority under the Electricity Act 2003,
Yes, ma'am.
Electricity Act 2003, and the appellate authority under its order dated under its different orders, just give a list of the orders which will set aside and remand back.
Below, in the first case,
No,
one
just,
page.
we are not saying, we are not,
Okay, I have,
give it.
I will give you.
While final part, we record it.
Yes, I,
What is it? Though noted that it is a clear case of tempering / theft of electricity meter or theft of electricity by tempering the meter, and therefore clause 5.A.4 will apply for assessment, will apply. But facing difficulty in applying the procedure as per clause 5.A.4.4, the learned appellate authority directed that assessment be made in terms of clause 4.2.2.4. 2.4. Mr. Kejriwal, learned counsel submits that when it is a case of theft of electricity, the most appropriate, the clause to be applied for assessment is clause 5.A.4.4.
read with serial number
4.4 and read with
serial number 9 of clause
serial number 9 of
6.2.11
clause 6.2.11
and clause 3D of annexure A to the supply. And
clause 3D of annexure A to the supply code. We'll record your submission, don't worry. Because supply of this code. Full stop. Mr. Kejriwal further contends that merely for the reason that the calculation, if made, assessment, if made in terms of clause 5.A.4.4 shall result in an adverse situation for the APDCL, the appellate authority was not within its jurisdiction to apply clause 4.2.2.4 in this present case. Accordingly, he submits that the assessment orders under challenge, appellate orders under challenge in the present proceeding is liable to be interfered. In support of such contention, Mr. Kejriwal relies on a decision of a coordinate bench dated 1/11/2022, rendered is WPC/5892/2017. Full stop. Per contra, Mr. Chaudhary submits that par contra, Mr. Chaudhary submits that though the ratio laid down in SM Siemens Industries, Udis bracket Supra, is applicable to the present case and the matter is required to be relegated to the authority so as to make an assessment in terms of clause 4.2.2.4 clause 5.A point 4.4
Read with clause 3D.
4. However, clause 3D and what you say?
Clause serial number 9 of
Serial
clause-
number 9 of
serial number 9 of clause 6.2.1.1.
6.2.2 and 2.1. And what is that appendix?
Appendix, this is when below the, in the earlier supply code. The
Comma
Paper-
shall not be, cannot be made applicable in this case. This is your case. This case. Considered the matter, full stop. And this court is in total agreement with the decision rendered in the rendered in SM Cement Industries. And therefore, the impugned appellate orders are liable to be set aside. Full stop. Accordingly, the following orders are set aside. Give the list. Following orders are cited, writ petitioner, give the writ petition number and order. Following orders are set aside.
17.
Give a list. Full stop.
Serial number
Full stop.
17.
Now, just let us understand this portion. You have set aside?
Your,
Set aside? Set aside. Now, give us what is your objection and what is his
your lordship may kindly come to page
Ah.
27.
27.
Before that, your lordship may kindly come to, I'm sorry.
Chapter
Your lordship may kindly
Chapter
come to
5.A.O of what is called name of
supply.
Electricity Supply Code and Related Matters Regulation 2004, hereinafter referred to as Regulation 2004, deals with interference with supply mains and apparatus. Clause 5.A.3.2 deals with deals with the deals with the action which can generally be treated as malpractice. Full stop. Subclause I of the aforesaid clause prescribes that interfering and tampering with the meter and metering system as detailed under section 135 within bracket 1 and under section 138 of the Electricity Act 2003 shall be treated as a malpractice. Okay.
He is also important. It deals with theft. He
The full stop. Theft of electricity as detailed under section 135 within bracket 1 of the Electricity Act 2003 is also brought under the purview of malpractice under subclause Z of the aforesaid clause 5.A.3.2. Full stop. 5.A.4 deals with method of assessment of the electricity charge payable in case of theft pending adjudication by the appropriate court.
Now your lordship 5A4.
Clause 5.A.4.4 deals with unmetered use of electricity within bracket theft of electricity and prescribes that when a consumer indulges in theft of electricity, the officer authorized in this behalf by the government of Assam may, without prejudice to its other right, will assess the quantum of electricity loss on the basis of assessed consumption of detected category as per table 6.2.1.1 and the connected load for a period of 12 months prior to the date of detection and will be billed at the rate of times of existing tariff. Therefore, in the case in hand,
Now serial number 9.
No, I'm coming. In the case in hand, there is no, in the given facts of the present case and the aforesaid prescription under the regulation 2004, this court is having no hesitation to hold that in the given case of the present case, it was the provision 5.A.4.4 which was to be made applicable. And though the learned appellate tribunal also conceded to such a proposition of law, however, directed the assessment in a different mode, which is not relatable to the present case. Present case. Now coming to
The method, my lord.
Yes.
Clause 6.2.1, page 30, my lord.
case.
30.
Now coming to the other limb of argument of Mr. Kejriwal, comma, clause 6.2.1.1, is not it?
Serial number 9.
Comma, deals with computation of load security. Load security prescribes in the table under such provision so far relating to HT-Roman 2 large industries, comma, connected over 100 kVA to 2500 kVA is 150 per kilowatt per month.
So if the connected load is 100, in that case, my monthly consumption as per this SS consumption will be 100 into 150. So that will be 15,000. Now, since this is the assessed consumption, and as per section 154 subsection 6, they have to determine on the loss. This another provision is prescribed at annexure A, page 32.
Yes.
This page 32.
30.
32.
Yes.
Explanation with example for implementation of provision of supply code regulation. Now, your lordship may kindly come to page 35. This is given, the formula is prescribed here.
A certain formula is provided in annexure A to the supply code. The supply code or rules, regulation.
Supply regulation.
Supply regulation 2004. As regards implementation of provision of supply code, and a formula has been provided in the appendix A.
Is clause 3D, page 35. For tempering.
And there is also provision for assessment of consumption of load for 12 months or recorded in the meter and the loss thereof under clause D of the aforesaid appendix. Full stop.
Subclause D, my lords, is only limited to,
We are not going to this is prescribes
because it is only related to tempering, my lords. Here is the case of theft also and
Okay.
unauthorized usage also.
okay.
But that perhaps is not the only applicable formula.
So we are not going what should be the formula. We are saying that let them apply the formula as prescribed under 2002. We are not expert bodies.
Yes.
Okay, now that's your argument next.
Kindly come to page 30. Their own judgment of the appellate authority judgment in another case. Page 11.
Mr. Kejriwal further contends that the therefore, in the aforesaid backdrop and proposition prescription made under the regulation, which is made in exercise of statutory power under the Electricity Act 2003, it is the bounden duty of the respondent authorities to apply the prescription made in the said regulation while making an assessment. Therefore, the contention of Mr. Kejriwal that along with the provision of clause 4.A.4.4, his
5.8.44.
5.A.4.4, his case should also be considered in terms of
5.8.44 read with clause 3D
Read-
of
read with clause 3D of
of the supply code.
of the supply code.
Annexure A to the supply.
Supply code, full stop. Such consideration, in the considered opinion of this court, in exercise of its judicial review shall not delve into the niceties of calculations and formulas. However, while disposing of this matter, setting aside the aforesaid orders, it is provided that the petitioner shall file a fresh representation claiming not only his right under 5.A.4.4, 544.4, but also he may insist upon applicability of
3D of annexure A.
clause 3D of the annexure A. In the aforesaid, on the basis of such representation, the assessment be made afresh.
Yes.
Such assessment be made within a period of
2 months.
2 months,
From the date
2
of
months
They
from.
will take into consideration their own appellate order. Your lordship may kindly
No,
say.
that they will
Your
consider.
lordship may kindly.
No, will not say that.
Never ending.
No, will not say.
Well,
See, it's a judicial procedure. Should we say that you consider a judgment? Will Supreme Court say that you consider that judgment? We'll consider, they will consider. That's
a
that's
reference
huh.
to the.
Needless to say that the petitioner shall be at liberty to place reliance upon the judgments of the tribunal as well as
Appellate
the appellate authority, as well as judgments of this courts and honorable apex court in this regard.
The review petition perhaps is also necessary, my lords, because the order in the writ, my lords, the writ of.
No, in the writ, he sought a subsequent review. Review has not granted.
No, review has been granted.
A review was granted.
In fact, the order was passed in review petition.
Okay, anyway.
There is a.
Okay, read it, order dated.
30th November.
Agos order
2023.
it is in a code in bench, pass in Swensu, read it.
Order dated 30th November 2023.
38th November 2023 in review petition number
15 of 2023.
15 of 2020. We do not know when we will get this order. All this have to be typed, huh? If necessary, have a consult. Don't make mistake.
I'm deeply aware.
Yes, next case. Sumi. Yes.
Lordship, kindly we look at last order.
Last order. This is item number
13, my lord.
1.
1-3.
Yes.
I have received instruction, my lord.
Uh.
My lord may kindly have a look the impugn order. It is in page-
500 imposition.
Yes,
Uh.
this honorable court has already passed interim order in the year 2017. And the term of the board is already over, my lord. The 5 years
So
term.
new board is not insisting. Tell us that we'll close it in terms of interim order.
Only 5,000 already imposed and
There is an
Madam-
interim order not to recover.
not to
It
recover.
is not recovered. We'll record that new board is not proposing to
Yes.
insist upon this. Therefore, this matter has become inspastus. Interim order, it is closed. It is closed and no instructions should be.
Lordship, I have received instruction though, but lordship may close this matter.
No, these matters should not be. Heard Mr. L.R. Mojumdar, learned counsel for the petitioner. Also M.S. Bora, learned learned standing counsel
Cooperation.
for the cooperation
For
department.
1 to 4, my lord.
For respondent number 1, 2, and 4. Yes, Bakolial? No. Gogoi? No. Okay. The petitioner is aggrieved by an order dated 27 to 2017, passed by the Assistant Register of Cooperative Societies, Hosai, by which a penalty of rupees 5,000 was imposed on the petitioner for an alleged act of making certain illegal changes in the membership register of Nilbagan GPSS Limited by including name of one Muhammad Nurul Haq in place of one alias Baru. Baru or Banu? Banu, alias Banu. It is the case of the petitioner that before passing the order of levying the penalty, the petitioner was not given an opportunity of hearing, and it is opportunity, and that petitioner had not made any, and inasmuch as it is the case of the petitioner that the petitioner had not made any change in the membership register as alleged in the order dated 27/2/2017. In the aforesaid factual backdrop, this court under its order dated
Lordship 29.
order dated
29/3/2017.
2017 state the aforesaid order dated 27/2/2017. Full stop. This court under its order dated 15/7/2024 sought under its order dated 11/3/2020 order dated 15/7/2024 sought instruction from the learned standing council standing council MS Bora learned standing council on instruction submits that pursuant to the interim order passed, no recovery was made, and the board concerned who imposed such penalty has in the meantime changed, and she has instruction to submit that the present board is not insisting upon continuation of such interim order. Full stop. In view of such submission, the impugned order dated 27/2/2017 and the writ petition stands closed by making the interim order dated closed. Parties to bear their own cost.
Deeply obliged, my lord.
Yes. Yes, 17.
By last order, my case there was fall for.
Uh-huh.
I received instruction also. It is in the Tada court also. Why it was called for Tada court, it was not reflected also.
Mr. K. Gogoi, learned additional senior government advocate Assam, pursuant to this court's order dated 22/7/2024 on instruction from Superintendent of Police Sibsagar, Assam, submits that the original case diary of Sibsagar PS case number 291/191 under section 365/30 IPC, read with section 3/4/5 of Tada within bracket P, was submitted before the learned designated court Guwahati through the district magistrate Sibsagar via a letter number SVM/Sibsagar PS case number 291/91/2023/525 dated 6/10/2023. It is not disclosed the reason. A copy of the said letter dated 6th of October 2023 is also produced by Mr. K. Gogoi along with the communication addressed to him by the concerned Superintendent of Police. Full stop. However, it is not known why such case diary was sent.
They might have filed again final report. Probably Tada section is there.
Tada is, what is the status of Tada today?
Tada is mind of it was initially for 5 years.
Now, what is the Tada Code 2020? What was the status of Tada Code?
Yeah, designated court is there.
Still
And
there.
Special.
Can we call for this case diary from?
Yes.
Okay, full
Special
stop.
the Assam is
Full stop.
Still
Pending. Okay. In the aforesaid backdrop, registry to verify and from the designated court Tada at Guwahati and call for the aforesaid case, scan copies of the aforesaid case diary by the next date fix. Full stop. List this matter on 30th of August
See, instead of scan copy, Lordship may.
Or call for the,
Scan copy.
this is the final report, call for the case diary, not scan copies, case diary. Give a date, Mr.
And my lord, may part of the report.
We will keep it.
Yes.
The communication address by the Superintendent of Police to Mr. K. Gogoi and the order communication dated 6th of October 2023 issued by the District Magistrate Shivsagar are kept on record and marked as X document X and Y.
Lordship. Oblige, Lordship.
When? List this matter on 30th of August,
Can it be on 29th?
29th of August.
29th.
Let
Oblige,
us see
Lordship.
what is what.
Oblige, Lordship.
Yes, Mr. Doctor.
Lordship, in this case, I have filed a writ petition for claiming compensation. After that, Lordship, an amount has been provided to us, Lordship, given to us, but we are not satisfied.
Sure.
And they, no, Lordship, they have, on last occasion, they have produced certain documents which they claim that they have given to us. That amount we have received. But my client, I took instruction that thereafter, Lordship, matter has been, a compensation amount has been revised. There was a multiplication factor was also added. That amount I could not receive. So if they have filed affidavit, then we can controvert it and submit, and matter can be disposed, Lordship. One affidavit from the government. They have not. NSDIL has already deposited that amount before the competent authority. But competent authority file a affidavit and annex the document. I will take the opportunity to controvert that statement, Lordship.
Okay, I will accept your controversy today to be an oath.
Lordship.
Tell us. Now, what kind of order we can pass in a writ proceeding?
No, Lordship. Till today, my client is not aware how much the amount and under what head and what was the revised rate of compensation.
So file a representation if you are not aggrieved
Lordship.
by the new determination, if at all, they will give you. And if you are aggrieved,
yes,
you will go to the referral court or it is an SNL Highway Act and arbitrator.
They have already approached and that amount has also been paid from the affidavit filed by the. So,
but government has not filed any affidavit to the deputy commissioner, the competent authority. This is the irony, Lordship, for me, Lordship.
For you, it may be irony, for us not.
Then Lordship.
We don't find any irony in this.
Then Lordship, I pay before Lordship can dispose of matter, directing the liberty.
See, Mr.
Granting me liberty to file a representation and with a direction to the
Doctor,
competent authority.
we are here to protect citizens' rights, no doubt about it. But that right is to be protected following due process of law.
Lordship.
It is not a bar that we cannot take up disputed matters. There is no bar. Our power is.
Yes, I understand.
But thing is that if we deal with all these kinds of petitions, where as efficacious remedy is granted and some determination is made. Suppose on admitted position some determination is made by the deputy commissioner on claim, then we can very well examine that. If you don't say that I want an enhancement or something like that. If you say that yes, this is determination, I am happy with this, but pay me this, then we can very well give you direction. No problem on that. But here is a case where you say that they have not paid. Now, why they have not paid? Let them pass a speaking order instead of, because we are not the adjudicating authority.
No, Lordship.
Isn't it?
Lordship.
Concept is this.
Yes.
We are not the adjudicating authority under Land Acquisition Act.
Lordship.
We are reed court.
Lordship, may I submit?
Yes.
So I'll file a
File details, whatever you want to say in the affidavit.
And they may be provided me the 3G list, Lordship.
They will provide whatever.
3G list. Lordship can observe it.
What is 3G list?
3G list is the determination of the compensation amount, Lordship.
Definitely they will give you.
The updated 3G list.
Moment you say that there is a higher revised determination, we'll say that let them, this is your claim.
3 times earlier they have not been provided.
Hard. And government also, we are looking at those important matters, there is no affidavit. And these matters, affidavits after affidavits.
The NHIDCL have filed affidavit and they were not satisfied with the compensation. So they have approached the arbitrator. And arbitrator, Lordship 28/5/19 passed
It
an
is the
order.
case heard Mr. P.P. Dotto, learned counsel for the petitioner. Also Mr. H. Sharma, learned state counsel representing the state respondents, and MS Bora for for respondent number 5, NHI DCL NMSP Mohanto Learned Standing Council Revenue. Full stop. According to the petitioner, 3 plots of land belonging to the petitioner covered by Patta number 8 of Dag number 573. All are same.
No,
And
Lordship,
and Patta number 9 of Dag number 529 of village Hukajan. Hukajan or Hukajan? Or Hukajan? Boka or Huka?
Lordship, Pata number 91. Lordship, paragraph 4, Lordship, page 4.
Huh?
I have given a list.
Hmm.
Table form.
Vishwanath district have been acquired by the respondent authority for construction of 4-lane national highway. But the respondent authority has not paid the determined compensation to the petitioner in respect of the acquired land. Full stop. The NHIDCL has filed an affidavit through the Deputy General Manager within bracket P, comma NHIDCL and contended that the petitioner has been paid due compensation, and being aggrieved, the petitioner had also approached the arbitrator for enhancement. Enhancement granted, and enhancement was also granted, and such enhancement has also been paid. Full stop. At that stage, the learned counsel for the petitioner submits that though such certain payments have been made
After the petition.
after filing of the writ petition, however, according to him, a revision of compensation has been made so far relating to the land of the petitioner and nearby lands, and such enhanced and revised compensation has not yet been paid. Full stop. In the aforesaid backdrop, Mr. H. Sharma, learned counsel representing the Deputy Commissioner, cum Collector, Vishwanath District, Vishwanath District, submits that such determination on the grievance of the petitioner can be considered by the collector himself and pass an order.
And competent authority.
Collector is the competent authority. Collector cum competent authority. Collector is the competent authority. He delegates his power to additional deputy commissioner. Land acquisition always the collector. His name changes. He becomes the collector, not the deputy commissioner. Akikul? By the deputy commissioner. At this stage, Mr. Doctor submits that though he is aware that a revised estimates rate has been revised, however, the final order determining such rates has not been furnished to him, and therefore a direction may also be issued to the competent authority to furnish such a list prepared under Section 3G of the Highways Act. Consider the submission and taking note of the consensus arrived at as well as the nature of litigation. This court is of the view that the present writ petition can be disposed of, directing the Deputy Commissioner cum competent authority to directing the petitioner to file a detailed application seeking the revised compensation before the district collector cum competent authority, and in the event such application is filed, the Deputy Commissioner shall consider the same and pass the speaking order, and if any enhancement is made as claimed by the petitioner, the copy of the order passed under section 3G of the Act may also be furnished to the petitioner. If they say we have not, then file it, yeah, full stop. Such exercise be completed within a period of 6 weeks from the date of 8 weeks from the date of receipt of a certified copy of this order to be furnished by the petitioner before the deputy collector come competent authority. This disposes the writ petitions. Writ petition. Yes.
Matter relates to illegal encroachment of land by the Army Authority of Narangi.
Yes, Mr. Sharma,
So-
NASG. There is some direction for demarcation and all. There is some water logging and all.
That, the court has directed the civil authorities to go and do the
Survey done, affidavit also filed.
Now, what is the stand now?
Affidavit stated that the land is standing in our name, but under the occupation of the army.
Who says that?
That is after the demarcation has been done by the circle officer. An affidavit has been.
Who says this by the circle officer?
Yes.
Yes. Then
And the demarcation was that through the GPS tagging because it's a hillock area.
yes. Now, what is the army state?
Lordship, let me take it up with the, I have not.
Will
received
pass an order
Lordship.
to respond to the affidavit of the circle officer.
Yes, Lordship.
Because circle officer is the revenue authority. So if he makes a stand that this is a patta land in possession of the army, only option left is either to challenge the decision by the army authority or to seek for acquisition, or requisition cannot be because it's a permanent.
In this case, the deputy commissioner has filed an affidavit earlier stating that whatever land has been given to the army authority, there's an external land, and for that purpose, government has collected premium from the army authority, not the Medi land has been given.
Okay.
And their stand is that the land has been acquired in the year 1962, whereas we have purchased the land in the.
So they will let the army respond because we will have to, if this, see, basically in this proceeding, we'll have to go by the stand of the revenue authority, not by the army's authority. Army, of course, will be at liberty to challenge such determination, challenge such inquiry. That is a different aspect of the matter. But so far relating the present writ petition, heard Mr. S. Deka, learned counsel for the petitioner. Also, Mr. H. Sharma, learned counsel for the respondent. 3 and 4. Pursuant to this court's earlier order, first of the grievance of the petitioner in nutshell is that his patta land measuring
10 bighas, 12 lesses,
10 bighas, 12 lesses
covered by DAG number 6.
I will not go to all this, 2 lesses, which are described in the writ petition, are being occupied by the army in the Narangi cantonment.
Narangi.
In the Narangi army, we'll say that army, illegally and without following due process of law and without paying any land acquisition compensation. Full stop. The deputy commissioner had filed an affidavit and has taken a stand. Thereafter, this court, considering the dispute, directed to have an inquiry done by the circle officer to ascertain the veracity of the claim of the petitioner. Accordingly, an inquiry has been made, and inquiry and demarcation has been made, and an affidavit, report or affidavit?
Affidavit.
An affidavit has been filed by the circle officer ascertaining the claim of the petitioner that the aforesaid land is in occupation, aforesaid patta land of the petitioner in the occupation of the armed forces. At this stage, Mr. Dev Chaudhary, Larnet ASJ submits that the respondent state may be directed to give copies of such affidavit to him so that the army armed forces authorities can respond to such assertion made by the revenue authorities. Full stop. Prayer is allowed. List this matter on
It may be fixed, Lordship. August first week, second week.
third week.
That should be after 3 weeks.
After 3 weeks, we are fixing it on 21st of August.
21st, I will be not available.
Okay, give a date.
Yeah, just
Not demarcated, will not say demarcated, and submitted a report.
that it falls with.
Demarcated, Lordship.
Huh?
Report says that, affidavit
No,
says
we'll
that.
say, let us
Yes.
Demarcation will be physical demarcation.
demarcated in map, demarcated in map.
No, no, the GPS tagging, the director of land record has.
Okay,
also-
let us not go to that, we'll decide because
conducted.
survey was conduct. I will correct this. Leave this method, give a date, Mr. Tara. 29th. Huh? 29th of August. You file this affidavit, you dispose it of pending since 2002. Yes, Mr. Okay. To be recorded,
Is my support.
to be recorded. Also, report ASGI as stated by Mr. Mehdi, CGSC.
Okay.
This support system is very important. Yes, what is this?
May I please, your Lordship? Lordship, so far as item number 17 is concerned, I may be allowed to withdraw this petition, Lordship.
Okay, item number
17.
17, MS N. Hawelia, Learned Counsel for the petitioner submits that she may be allowed to withdraw this petition. Accordingly, the present petition stands dismissed on withdrawal.
Lordship,
What
so-
about 18?
Lordship, item number 18 is covered, Lordship, because Lordship, what is the case about his?
Yes. Kejriwal is not here. In Aizal.
Place the judgment of this.
Don't put her in problem.
Oh.
Kejriwal is not here.
Ji.
Not Kejriwal, yeah, Kel. It is submitted that Mr. SC Kel, Learned Standing Counsel for CST, is not available today. Accordingly, prayer for adjournment is made. Full stop. On the other hand, MS Hawelia, Learned Counsel for the petitioner submits that the matter may be adjourned. However, the present writ petition is covered by the ratio laid down in WPC 740/2020 passed on 13/5/2020. ऊपर लिखिबो MS North is High Tech versus Union of India and others.
May verify.
Full stop. In view of the aforesaid, the learned, you are Mr. Your Mrs. Your name is MS? Huh?
N Kakoti.
N Kakoti, MS N Kakoti, Learned Counsel, junior to Mr. SC Kyle, shall apprise as senior whether the aforesaid the decision rendered in Northeast High Tech within bracket Supra covers the claim of the present petitioner. List this matter on
28 also, same 28 August.
28th of August.
Much
28.
28.
28.
280, Lordship.
Okay.
Much obliged.
Yes.
May I please, Your Lordship? Matter relates to
Conversion.
conversion regular.
Agriculture to
Commercial.
commercial. Which is the place?
The mandamus can be issued.
No, no, cannot be. What is their stand?
Affidavit not yet filed.
Affidavit not yet
Government of
filed,
time.
but Lordship.
Okay, Mr. H. Sharma, Learned Counsel for the petitioner, submits that the state may be granted 6 weeks time to file affidavit in issue. Prayer is allowed, list accordingly. Yes, Mr. Mohanto.
It is relating to issuing of notice under section 13(2) of the SRPC Act.
Yes.
In respect of my two lands, one is term loan and one is whether cash credit. That was whether offered to me by in against the security created. That is one stock and another is one land. So my lord, after they are saying that this NPA was declared on 28 and notice was served on 29, but in fact on 28, they used to receive the amount that was I
Now,
paid.
what is your present status?
Present status is, my lord, the land, whatever I placed, my lord, that is, my lord, already been, my lord, engulfed by the water. This is river, my lord, Moravur,
No, that is not the issue.
Yes,
Whether you have paid, done something, because REIT court cannot entertain all
That
this.
is, I know, my lord, this is a
If
very
you know that, you'll have to dismiss. Tell us, this retreat petitioners entertained only on the statement that you are regularly paying
I am
and
paying, my lord, I am paying. So
yes,
that-
what is your instruction?
The bank has not, entered their
Has not.
affidavit and everything is.
They have not paid, the defaulter there.
What is the present status?
At this stage, my lord, today I talked to my client, my lord, he is in a very precarious condition, not able to make the payment now. So my lord, there's some time may be granted, my lord, because he is able to pay, my lord, he is ready to pay, but the time will take, my lord.
The present writ petition is filed assailing the action of the respondent bank taking action under the SARFAESI Acts. Full stop. This court only and this court entertained this application only on the basis of a statement of the learned counsel that the petitioner is paying the installments.
Even after NPA also.
Installments. NPA is a SARFAESI. NPA after
No, they are after, without an NPA, my lord, they cannot issue the SRPC notice. So
that
NPA,
can
my
be
lord, they-
determined, that is determined by the DRT.
Correct.
We can give the provision 17.
Yes.
That is also a part of this.
Yes,
Entertain. And this
34
court,
also are barred.
this writ petition was entertained even if the petitioner having a remedy under section 17 of the SARFAESI Act only on the statement made by the learned counsel for the petitioner that the petitioner is willing to go for an one-time settlement by making the bank a reasonable offer. Where have you made this offer?
But I tried to approach them, but they are not cooperating anything, my lord.
Okay.
Even they are not able to talk to
Learned
me.
counsel for the bank submits that no such neither any such proposal has been given nor any payment has been made till date. Therefore, such writ petition shall not be entertained and the petitioner shall be relegated to the appropriate forum under section 17 of the Act. Mr. Mahanta, learned counsel for the petitioner on instruction submits that the petitioner is in a very precarious financial condition and therefore he has not been able to make any payment. And though he tried to make an offer of one-time settlement, the bank has not accepted the same. However, such statement has been refuted by the learned counsel for the bank. The Honorable Apex Court time and again has held that when a matter relates to securitization and reconstruction of so and so Act, SARFAESI Act, this court should not exercise the power of judicial review except in extraordinary cases. Full stop. Inasmuch as the petitioner shall have an efficacious remedy to deal with all the grievances that he has raised in this writ petition by a competent authority created under the Act. In view of the aforesaid, the present writ petition
My lord,
this means with a liberty to the petitioner to approach the appropriate authority if so advised or to settle the dispute outside the court, full stop. In the event such a proposal is given, the bank may consider the same as per extant norms, full stop.
If the petitioner wants to go to my lord DRT now, because of the limitation, my lord, he'll be barred. So that may be, my lord, considered.
There is a recent Supreme Court judgment.
My lord, it is a liberty can be, my lord, dear lordship.
No,
Because they are wrong court. If you suppose it is a wrong court, so that can be.
that they can take, but court says that this court cannot condone a delay when it's a specific.
But that can be, my lord, considered.
Okay,
That direction may be
the
given.
period spent in this court may be considered while condoning the
Depending
delay
appeal, my lord.
by the competent tribunal if such application is filed. Upper likhi dibo hard visa so and so for the bank. Respond. Yes. What happened? Election is over?
My lord, what happens, the report has been submitted as per the bylaw of 2004. But the bylaw was already amended in 2019. And as per 2019.
Now who is running the show?
We are because as per the order of the High Court, we are the petitioner committee.
Run it, we'll adjourn it. You are running it, you run it.
Lock was not open. My lord, the lock, they have used it done right. That is why this petition was
Let
filed.
the God be in peace for some time.
And my prayer will be that.
Don't fight, let the God be peaceful.
My prayer will be that, my lord.
Yes.
Let them, there be a press meeting and let them attend the meeting. We will hold it. If they have-
Enjoy you are running the show, you enjoy it.
No, but the lock is not open.
Who will open the lock? Lock of what?
Lock, that is the office lock.
Office, let the office lock be there. You are being able to pray.
No, everybody is allowed to pray.
So pray.
But the only
God,
meeting-
what
meeting-
wants, God wants is the prayer. Not this lock and key and fight.
No, I have the prayer.
No, we are not disposing of this.
So, Lordship, see the prayer.
Yes, what you say?
Lordship, I'm appearing from the GID department. On the last occasion, Lordship, on 18th May, we were asked to file the affidavit additional. We have filed an affidavit and they, my lord, they had taken time to file a reply. I've seen in the record, my lord, some reply they have filed, but we haven't received any copy as on date.
Let's
That's why, my lord, I need to
give a copy.
Lord, basically go through it, my lord, as to what he has given written there, my lord, against the report which I've given, the inquiry report, which I've.
Okay, give a copy. On the prayer of Mr. Fukan, learned counsel for the respondent.
My lord, my lord, we're not a party. We were made to, by an order dated to bring a report. So.
Counsel for the, on, as agreed to by the learned counsel for the parties.
Furnishing the copy right now.
Give.
So that may be recorded, my lord. Kindly.
A reply affidavit has been filed by the petitioner against the affidavit in opposition filed by
The General Administration Department.
General Administration Department. Full stop. The copy of the same is furnished today in the court itself to the Learned Standing Council for the GAD. In view of the aforesaid, the GAD, Learned Standing Council GAD, press for and is granted to respond and go through the same. Prayer is allowed. List this matter.
I want the disposal of the case.
Enjoy the show.
Let after 2 weeks, my lord. Please.
Give a date after 2 weeks.
The dispute between the pockets and pocket. Both side pocket.
Why pockets are required for God's people can directly pray? Why in between intermediary?
My lord, in spite of the order of the High Court.
Tell us why intermediary is required.
Because they did
Let the district administration run the management.
After the order of the High Court.
Pockets are required.
After order of the High Court.
There should be connection between the person and his God. No middleman in between.
Correct. Your lordship
Yes,
is correct.
next case.
Lordship is correct. Only the DC is not hampering us. Deputy Commissioner. He did not open the lock of our office. That is the case, madam. Oblige, madam. I have brought the book also bylaw.
Yes. We'll hear on the next day. We'll finish it up. Yes, next. দিয়া সবরে গরম লাগছে Yes, Ahmed.
My lord, in this case,
Mm,
I occupied a plot of land
mm,
and I also applied for allotment.
mm.
Then my case has been referred to the authority for allotment.
Have you been evicted? There
Not
is only an apprehension.
No, because they are not taking any decisions. They
Just
lost
let them file an affidavit. You enjoy in view of the pendency of the writ petition. Whenever they come to evict, you say that writ petition is pending, it is under consideration. Yes, London State Council press for and is granted 4 weeks time to file affidavit.
Hello.
Okay.
There is no interim order.
They will not evict you. None appears for the petitioner. The learned state council press for and is granted
4 weeks time.
4 weeks time, 6 weeks time to file affidavit in opposition. Interim order pass earlier shall continue till the next date of listing.
Yeah, please, Lordship.
List before any other bench without me. Yes.
Lordship, engage counsel of this case. Engage counsel of this case have some
Yes, Chaudhary, are you here?
medical
Sorry, my lord,
offenses.
in 27 I was present, my lord, I could not up the case, my lord, just.
This is the problem. JMS Chaudhary, huh? None appears at JMS Chaudhary. Yes.
For GMC on behalf of Mr. P. Naik.
Let's give the list, give the list. Don't disturb us. Give the list, yes. Your senior is not on the prayer of the learned counsel for the petitioner. Matter stands adjourned, full stop. In the meantime, the petitioner may file reply to the affidavit in the position filed by respondent number 4. You are respondent number 4. What is your name? H. Borua. On behalf of Mr. S. Bora, representing CMD, GMC.
Representing Mr. P. Nayak.
P. Nayak, not S. Bora. P. Nayak, representing
Lordship, GMC.
GMC. P. Nayak is GMC or S. Bora is GMC? Okay. 634 is a নতুন case of 23. Yes.
May I please, your lordship?
Ah.
Your lordship, in this case, I am the Rayat in respect of land measuring 2 biga 7 less. And while constructing the Adawari bus stands, they acquired my land 1 biga 1 katta 8 less. But entire land has been taken by the government, your lordship.
Yes. And so many cases.
We already in our affidavit, lordship.
What is the affidavit?
6.
What is your stand?
Lordship, in the paragraph 6, my lord, we have stated that.
What have you stated?
Kindly goes to the paragraph 6.
You are Bhola Haloi?
I'm the son of Bhola Haloi.
Okay, Ajit Chandra Haloi.
Some compensation amount has been paid.
Your lordship, they said that out of this 2 biga 7 lessa, 1 katta 13 lessa is outside of the Adawari estate. And 2 katta 6 lessa is inside of the Adawari estate, your lordship. And this land is inside the Adawari estate without giving any compensation since construction.
The last paragraph, lordship, may kindly goes. The mention the petitioner is not the patada in the concerned land, lordship.
I'm not the patada, I'm the Rayat.
To file a reply to this.
I'll file it.
So that we can. Mr. N. Jha, learned counsel for the petitioner. expressed that he may be granted 2 weeks time to file a reply to the affidavit in opposition filed by respondent number
2, Lordship.
2.
Your Lordship.
Prayer is allowed, list after 2 weeks.
Lordship.
You file an affidavit, keep the documents, how you write, then at least we can ask them to verify.
Your
What is the, what will the Rayati Khati answer and all of this. Riot will definitely have a right. Yes, next.
Can be taken up after some time.
Sometime is difficult today. Yes, what is the issue, Mr. Dhar? Who are you, Mr. Dhar?
I'm representing the chairman.
Silchar.
Municipal Board.
Silchar Municipal.
Karimganj Municipal Board.
Huh? Karimganj.
Municipal Board.
Now, what is your claim?
We are claiming fund of the KIST money plus the tender amount, my lord.
Well, there are some disputed question of facts because he has already collected for some period. So he wants refund of.
What is your decision? Any decision taken on his
No,
representation?
because there are some disputed question. of fact
You
that
can
was
say that you are
addressed-
not entitled.
Yes, the government chief.
Okay, we'll adjourn this today.
Fine.
List this matter on as agreed to by the learned council for the parties. List this matter. Any urgency? Nobody is having any urgency. After 3 weeks.
Okay.
You also know
Yes.
your limitation.
Yes, my lord.
He also knows his limitation.
We have communicated to the parties regarding.
Understand? I've seen that. Okay. Let's have some breathing space for this place. Item? Yes, Kalita.
Regarding some also default of payment regarding providing fund also.
Providing fund for what?
This petitioner is a company lordship tree garden relating to lordship mainly dealing with production of tea and selling it lordship. Recovery certificate was issued lordship which
Then
we have challenge in this case.
now any stay?
Yeah, lordship, in the first day lordship was.
But
this
have you
was
made
this
payment?
Payment we have already made 50 lakhs lordship.
Ah.
And then subsequent there was also the order is there. But lordship now this company is also loss making company and they are going to sell their property lordship.
Mr. J. Kalita, learned counsel for the petitioner submits that pursuant to this court's order.
Mr. Senior Counsel, Mr. NC Das, he is appearing
My
online,
lord,
lordship.
Just I am interviewing, my lord. White order dated 16/8/2023.
No, that is what I am dictating.
My lord.
Today we are not
This is-
taking any coercive action against him. Today we are giving him a chance.
No, my lord, on the white order 16/8/2023, my lord.
Yes,
the
yes, just
petitioner
wait.
was dedicated to,
We are
to
balancing it
deposit a
today
proper amount of
for some
not
other
my lord.
reason.
That amount of till now they have not deposited, my
Our
lord.
balance is?
Balance is total PF dues is 6 crores. And
Lordship,
gratuity dues is 2 crores,
I am
lordship.
not admitting that fact because my client is saying that there is some discrepancies in the calculation regarding the.
Yes, give a file and affidavit and see, Mr. Kolita, we understand your financial condition, but at the same time, this money are meant for the
For the levels.
this
Very
workers.
good, my lord.
These are the
Three
workers.
employees, my
So
lord.
some respite here and there is fine, but not beyond that.
Yes, lordship. We will pay lordship. We are already preparing to pay lordship.
You do, you may think over, otherwise,
Yes.
whole garden will go from your hand.
Yes,
They will
yes.
put some administrator, sell it.
Already lordship they have issued notice.
Lordship,
That's about
stay was
proceeding
granted
that way.
subject to the condition
That
that
is
they
already, my
deposit an
lord.
amount.
Like,
Okay,
the renewal properties
this
of the
court under
petitioner
this
has
order
already
dated
been closed, my lord.
28/7/2023. Granted an interim protection to the petitioner against sale proclamation dated 14/7/2023 issued by the respondent
Recovery
authorities,
officer.
respondent provident fund authorities, who is being represented by Mr. NC Das, Lanet Senior Counsel, subject to deposit of rupees 50 lakhs by the petitioner within 14th of August 2023. Have you paid that?
Yes, that's it.
That they have paid.
So-
Remaining 30 lakhs, they have
Okay,
not paid.
however, another amount was there. Where is that 30 lakhs?
30
16,
lakhs, lordship,
16/8
point number 6. Point
16/8.
number 6 of the order dated 16/8/23, lordship.
16/8, na?
16/8.
First up, though such amount has been paid, it is urged by Mr. Das Lanet Senior Counsel that the amount of rupees 30 lakhs directed to be paid by this court under its order dated 2023 has not been paid till date, though the direction was issued on 14/9/2023. Full stop. Be that as it may, as Mr. Kolita seeks for some time to complete his instruction and file an affidavit in what manner they are proposing to clear the dues of the Provident Fund, the matter stands adjourned and be listed on.
So 6 weeks.
Listed on, give it it.
6 weeks is too long, Lordship. It can be after 4
There's
weeks.
some urgency, my lord.
Lordship.
At
the time, we may also clear the amount.
But see, Mr. Kolita, we may grant you 6 weeks, no problem on that, but
We'll make our
that will be the last breath of this case until and unless you come and say this, yes, there are dispute, these are the dispute, but whatever is admitted, we have paid it.
Yes.
Okay?
No, please, my lord, let there be direction for
Hard
making
acceptance.
deposit of this check, my lord.
Okay. Fantastic. Hearing the no. Okay. What order should we pass?
Because the advocates are not fall under the service tax.
Ah.
That notification is also very clear. Earlier cases, let's see, whatever only notice was challenged, that has been put under challenge. In this case, final order has been passed. There is no problem under section 74 or lots may pass order, setting aside that order lots because notification.
Now tell us, is there any appeal rise here
Appeal lies.
against this order? So therefore, we will clarify it that though appeal lies, since they cannot even issue a notice to a lawyer in terms of the notification, this court has exercised its jurisdiction.
That can.
Give the notification. I'm not feeling well, so not dictating right now.
26.
Not dictating right now. You may get it next Friday or something like that. Notification? Okay, dictate. Take down. Take down. Take down. Hard Mr. B.D. Das Lanet Senior Counsel, assisted by J. Lotha.
If your lordship looks into this index, initial notice was given on 33/22.
Also heard Mr. S. Sikar, Lanet Standing Counsel for the
CGST.
Lanet Standing Counsel, CGST. The petitioner is a legal practitioner of Guwahati High Court since 1991. A notice, the respondent authorities issued a notice dated 30/3/2022 asking the petitioner to pay a service tax amounting to rupees 134,193 under section 78 of the Finance Act 1994 for the financial year 2014-15 along with penalty of rupees 10,000 under section 77 within bracket 1 of the Finance Act 1994. Full stop. Subsequent to after receipt of the notice, the petitioner submitted a representation on 19/4/2022 raising an objection that petitioner being an advocate is exempted for payment of service tax in terms of the notification number 30/2012, that's service tax dated 20/06/2012 issued by the Finance Department, Government of India. Accordingly, prayer was made to exempt the petitioner from payment of GST amount in as much as jurisdiction of the authority was also raised. Also, the petitioner also relied on an order dated 27/11/2021 passed by, where is that?
19.
Page?
19.
Uh,
Assistant Commissioner.
Passed by Assistant Commissioner
GST and Central Excise.
CGST Office of the Commissioner, CGST, Commissioner at Guwahati, CGST, Commissioner, CGST, Commissioner at Guwahati. Isn't it?
Yes.
Commissioner at Guwahati. Whereby in similar circumstances, similar notice issued against the practicing advocates were set aside, isn't it?
Yes.
Set aside. However,
Exempted from payment of
the-
service tax.
set aside, and it was observed that the advocates, in terms of the notification dated 26/12 to 20/06/2012, the advocates are not entitled for payment of GST. However, without considering the said representation dated 19/4/2022, in a recovery notice dated 6/6/2024 was issued, being agreed the present petition is filed. Full stop. Mr. Asikal, in his usual fairness, submits that the case of the petitioner shall be covered by the notification dated 20/06/2012, whereby the practicing advocates were exempted for payment of GST. However, at the same time, he submits that against the order of commissioner, there is a provision of appeal. Full stop. We have considered the arguments advanced by the learned counsel for the parties. Perusal of the material, it is absolutely clear that the advocate clear that the petitioner's case is covered under the notification dated 20/6/2012, and therefore he is not entitled for payment of tax. Full stop. Such facts was also brought to the notice of the authority by way of a representation by the petitioner, and the fact also remains that in similar circumstances, the appellate authority, that is the Commissioner of Taxes, has interfered with such decision. That being the position, this court is of the view that while issuing the notice and doing the recovery, the authority has acted without jurisdiction, and therefore there shall be no bar to exercise the power of the Article 226 in the given facts of the present case. Given facts of the present case. Accordingly, the impugned decision dated impugned notice dated
6/6/24.
6/6/2024
Recovery of service tax.
stands state aside, as well as the demand dated accordingly.
Lecture 1, page 13.
Accordingly, the notice dated 33/2022, as well as the recovery notice dated 6/6/2014 are set aside and quashed.
This is a final order.
Final order. Okay, final order dated
30th of March 2022.
okay. Very good.
Deputy President, what has taken pain. Not at all.
No, sometimes. Robert. তিনটা ম্যাটার আছে আর না জানি না
Maybe the lordship.
Yes.
Lordship, the matter pertains to non-refund of excess TDS deducted from account.
Yes, what will be done today?
Lordship, in the affidavit, they have admitted the claims.
Now what to be done today? Yes, Mr. Gogo, what to say?
Otherwise, my lord, we have filed the affidavit.
What is your stand?
Our stand is, my lord, though we have received in time,
Ah.
but there's some delay on our part in processing it.
So therefore you want he is entitled for refund,
That part, my lord, they have not disputed in the affidavit.
not disputed.
Not disputed, my lord. Only one para, para 50.
Okay, hard. Just take down. I will go to affidavit. Hard, Mr. S. Mitra, learned counsel for the petitioner. But for everybody, you may not. These orders may not be uploaded today, huh? The grievance of the petitioner in this case is that, despite repeated requests made by it, the refund of excess TDS deducted from the account of the petitioner has not been refunded till date. Full stop. This court, under this order dated 13/9/2023, issued a notice. Full stop. Now, in the meantime, it is refunded?
No, lordship.
No, no, comma, full stop. The respondent authorities have filed an affidavit.
Page 240, para 12.
Huh?
Para 12 and 13.
Para 12 and 13 statement, and has taken
242, para 15.
has taken a stand that while not disputing the claim of refund by the petitioner, had taken a stand that the refund applications were received by the office on 24/3/2014 for the assessment year 2011-12
11,
and
12, 12,
and
13,
2012-13
and 13, 14.
and 12-13 and the refund claim for the
13,
assessment year 2013-14, they received the refund application on 27/12/2016. It is their stand that concerned dealings assistant did not put up the refund applications on 4/3/2014 for on the date it was filed. And therefore, no order could be made for disposal of the refund application by the assessing officer holding the charge of the concerned circle. In view of the aforesaid, this court is of the considered opinion that this writ petition can be disposed of, directing the assessee's officer holding the charge of the circle to take on record the refund application and dispose of the same within a period of 4 weeks from today. Full stop.
One observation also will be entitled to interest also. So in accordance with law, that may be.
That see, income tax, you are getting refund, interest automatically will get it. We need not pass an order. Full stop, full stop. Claim of interest, if any, but also be considered by the said circle officer. Full stop. Said circle, said assessing officer. Full stop. Accordingly, the present writ petition says dispose of to exercise the entire exercise within a period of 6 weeks from receipt of a certified copy of this order to be filed by the petitioner before respondent number. D. Gogoi, huh?
3.
For the respondent, D. Gogoi. Respondent number 3. Okay. Dispose of.
Obliged lordship. Oh, it is respondent number 5.
Respondent number 5.
Yes. Yes, lordship.
Respondent
5.
Yes, Mr. Chaudhuri.
Lordship is not keeping well, so if it is taken on any other time.
No, they need an affidavit. No, keeping not well. Okay, we can. Premium not accepted. Who not accepted premium? Oh, that one list, one got some land.
Yes.
File an affidavit.
I need some time also.
File an affidavit. Maybe some delay in deposit.
There is, my lord, one notification is there. There is a period, my lord. Within that period, they have to submit the.
While taking this bench, I always recall the class 5 lesson of the rule of the road. And I think this all officers and all bureaucrats should be read that Nadim Gardiner's article, The Rule of the Road. I think you have also read it. The rule is to facilitate, not to discard. Yes. Mr. J. Hendick, learned counsel for the petitioner. Sorry, respondent.
Respondent lordship.
Respondent number 5 and 6.
4, 5, 6.
4, 5, and 6. And
not 4, so lordship.
5 and 6.
only.
I'm better aware than you. 5 and 6. And MSPR Mohanto, learned standing counsel for Revenue Department, appearing on behalf of respondent number 1, 2, 3, and 4. Is that it?
Lordship.
Praise for and is granted 2 weeks time. 3 weeks time to file a petition. List this matter thereafter. Yes.
I need some time to file my affidavit. Or
What affidavit? Pay it.
Lordship,
Admitted.
in that case, Lordship, pass the order in the line of Tom Serali, Lordship.
What Tom Sirali? Tom Sirali's days are gone. There is no, Mr. Gogo will be in a better position. Now this budget is sanctioned against a specific work. Yes, now not like that Tom Sirali's days. There will be, PWD will be given a budget. From that they will give seriatim. Now you cannot give money meant for Jogen Hendik to Mr. Gogoi. As simple as that. You will have to have a sanction against a specific work. So how can we pass an order after ARBM on behalf the Tom Serali? I do not think, except the principle that Reed Court can exercise power on the basis of admitted position, nothing.
Anyway, Lordship, the chief engineer will examine the case and.
Hard. You are Mr.
Prakash Bora.
P.
P. Bora.
P. Bora, learned counsel for the petitioner. And Mr.
N. Upadhyay, Lordship.
Upadhyay, learned standing counsel for the
Irrigation, Lordship.
irrigation department. The present writ petition,
Out of 94, 81 has been paid, Lordship.
that is what,
Lordship.
part is made
Lord-
payment,
Lord.
part is paid. The case of the petitioner is that pursuant to a tender process, sir, for everybody, hearing will not be possible. Any urgency, please tell us after some time. This is the last case, I think. No, here, admission. Okay. No. Pursuant to a tender process, it is a case of the petitioner that pursuant to a tender process, the petitioner was awarded with work of providing irrigation facilities at Bor, Jurai and Mohisa area under AIBP during the year 2013-14. Full stop. He claims certain unpaid amount of bill for execution of the aforesaid work, though according to the petitioner, he could complete only 35% of the work and for the reason of premature cancellation. Full stop. Referring to Annexure 4, Annexure R of the writ petition, Mr. Bora, no? P. Bora,
Yes, P. Bora.
P. Bora, learned counsel submits that an amount of rupees 94 out of an total due of the petitioner is 94,54,518. However, an amount of rupees 81,69,252 has already been paid, leaving a balance of 12,85,266. Full stop. At this stage, Mr. Upadhyay, learned irrigation standing counsel for irrigation department, submits that the matter may be relegated to the commissioner and secretary,
No, chief engineer, Lordship.
chief engineer, irrigation department
Sanmay.
to consider the claim of the petitioner, and if the amount due is admitted, and in after verification, if it is found that amount due is admitted, the department shall definitely pay such amount within a period of 6 weeks from the date of verification.
Lord.
From the date of verification, if found admitted.
Lord.
Full stop. In view of the Mr. Bora, learned counsel for the petitioner, submits that matter may be disposed of as proposed by Mr. N. Upadhyay. Accordingly, in view of the aforesaid consensus, this present petition shall dispose of, directing the respondent, directing the chief engineer, irrigation department to consider the claim of the petitioner for payment of balance amount of rupees 12,85,266 after due verification whether the said amount, whether the petitioner is entitled for such due, and if it is found that such amount is due, the payment be made within 6 weeks from the
First
date
ver-
of,
first
de-
verification.
so from the date of determination,
Lord.
determination, full stop. The determination we made within 6 weeks from the date of receipt of a certified copy of this order to be furnished by the petitioner before the chief engineer irrigation department. The petitioner shall be at liberty to file a fresh representation along with the copy of this order. Full stop. This disposes the representation. Yes, next. Highly obliged. Yes.
Lordship, here in this matter, Lordship, I need a week's.
Upamanyu,
Yes, Lordship.
learned standing counsel for health department submits that though he assured this court that required instruction sought for by this court shall be filed by an affidavit within a period of 10 days from today. However, due to his personal difficulty, he could not file such. Otherwise, I cannot condone. Personal difficulty, he could not file the same. Accordingly, he prays for 2 weeks time to file the affidavit.
Receive instruction and file affidavit.
Receive instruction and file the affidavit. Prayer is allowed. List this matter on. Give a date after 2 weeks. File it. File it.
Yes, Lordship.
But the specific order.
Yes, Lordship. August.
16th of August.
Highly obliged, Lordship.
Yes.
Please, Your Lordship.
Yes.
I'm praying on behalf of Mr. D. Das, Lordship. who is
Okay. What
the
is
Lordship.
this? Said
Legal said.
that you have already demolished.
No, no. Getting a stay order. That's
Who are you?
because we are the respondent number 6, 19 flat owners without water for the last 2 years.
Lordship, Mr. Didas is not
Okay.
well, Lordship. His letter of absence is also there, Lord.
Okay, Mr. A prayer for adjournment on behalf of Mr. D. Das is made. Full stop. Such prayer was also allowed on last occasion. On the other hand, the learned counsel for the respondent number 6 submits that for is a society. Respondent number 6 submits that for the operation of the interim order, the petitioner, the flat owners of the flat in question, numbering 19 are facing serious problem. Full stop. Mr. S. Bora, learned counsel for the GMC, also submits that the construction which was sought to be demolished by the GMC authorities is absolutely an illegal construction, and therefore the interim orders shall be vacated. Full stop. As the prayer for adjournment is made on the ground of Mr. D, held ground of Mr. Didas, matter stands adjourned today and will be listed on Friday next. Full stop. Friday next. By the time, if Mr. Das is Das still remains unwell, the petitioner may arrange for alternative lawyers. Interim order passerelle shall continue till then.
690. Obliged.
Yes, Matasan Kun is here. I today not possible.
Interim order may be
Okay.
continued. Last order was there.
As agreed to by the learned counsel. What is the urgency here?
Provident fund matter, my lord.
Okay.
There is a order operating, staying the demand notice.
Okay, you are the writ petitioner.
Yes, ma'am.
As agreed to by the learned counsel for the parties, list this matter on
My lord, in August.
August last part, give a date. 30th of August 2024. Interim order passerelle shall continue till the next date of listing. Yes, you want to say something?
The last matter regarding the deed Das,
Uh,
he will be unable till 3rd of August.
Okay,
So it may be after.
okay, list this matter. Except of Friday, give this matter on.
It's 6th August.
6th of August.
6th August.
Okay, 6th of August.
I'm so very sorry for the inconvenience.
No, give us the dates.
My lord, on
See, I do not know. You should be thorough in this code at least.
understand my
Yes.
my mistake, my lord. On-
Because see, we'll have to fill 65 lists.
I understand.
Those days are gone. That will hear matter after matter. Those days are gone. Yes.
On 24th of May in IA number 440, my lord,
Mm.
the interim was
So
granted
according to you, is the interim order still operating?
it was until 24th of July.
Mm.
It was till 24th of July. 24th of July matter was fixed. The main matter was fixed.
Mm.
And the public prosecutor took time to go through the copy. And this was
Okay,
also
this
considered
court,
that
this was not, okay.
interim was already there, therefore
Okay,
it's all right.
due to paucity of time, this matter could not be taken up. Accordingly, list this matter. I will take it after 19th. List this matter on 19th of August 2024. In the meantime, interim order passed earlier on.
24/5/24.
No,
24, no, 24/5/24.
sure.
My lord, yes, my lord.
24/5/24. That first order second order where first order was granted, then you did not appear, then there is an extension. That extension order.
Now there are no interim orders, my lord.
No, extension.
Okay, that 24/5/24.
24/5/24 shall continue.
I'm grateful.
We'll see on the next date, 19th.
Can it be, my lord, up to date LCA?
In the meantime, the registry
Up-to-date
to
status
call for
report.
scanned copies of the
Up to date.
Report because it
up-to-date
is-
status report along with statement of witnesses if any
I've already
examined.
annexed them.
No, in between. Okay, we'll pass this order.
Let there be a fixed date, my
We
lord.
have given fix 19th of
I'm
August.
grateful.
19th of August.
Oh,
Yes.
Lordship, yes, my lord. Item number 1 and 2, Lordship, there regarding the whether search sheet has been laid down or not. In item number 1, my lord, search sheet not laid, my lord. But in item number 2, my lord, I pray that it may be listed tomorrow, day after tomorrow, if your lordship convenience, because my lord, it is my lord cyber PS that has to be, my lord, but that instruction is
I
not
think we have already signed it, no? The two bills uploaded.
one. At least one, my lord, lordship can.
Okay,
discuss.
first one you say that
Yes, not
that
right.
Bilal Hussain.
Yes, Bilal, my lord, I want instruction, my lord. That has
Bilal, you want instruction.
other, I have
Now,
instruction.
where is the other? He has already might have intimated the
No, that is
client.
at second, my lord. It is they know that instruction.
Okay.
Was my first, my lord, it can be intimated because such is not filed.
You do one thing.
Loss.
We will keep this order as it is.
Loss. Yes,
Okay.
yes.
Call we are not listing it tomorrow again.
If I get it also
If you
today,
get
my
the
lord,
information, you give the information. We'll not sign and upload this order today.
Yes, yes, that.
Okay. You are also there?
Yes.
Okay.
Item
We'll
2.
not upload the order today.
Right.
Just intimate, then we'll do whatever it
Today
is
also if I
necessary.
get, I will submit. With
Just you inform and be present in the morning, both of you, for 5 minutes.
yes, yes.
Okay.
Loss.
At 10:30.
Loss. Loss.
Don't show disposal. No, okay, you'll have to. Okay, list this method tomorrow. By slip. Item?
Item 2.
Item
Only 2. One.
Okay, by list it will come tomorrow. By slip.
Of less.
There are many technical problems. You cannot do also because we'll have to.
Yes, yes, now it is
That's
my lord.
what is the disposal, what
Yes,
is not.
yes.
Everything needs to be uploaded by
Yes, yes,
evening.
now it is my lord. Everything has to be uploaded.